May I mention one contempt application was
Lordship, may I?
Just together. Private respondent constructing illegal construction on the pond, my lord.
Lordship, may I have your Lordship's leave for mentioning a matter for upgradation? It's 169 in the monthly list. Lordship, earlier I'd given a direction for upgradation.
What is the matter, madam?
Lordship, here we had the person concerned had found a big corruption racket. He had brought about complaints against that racket. Those persons came in appeal before your Lordship. Your Lordship has given them an order of stay. They are enjoying the stay. More corruption is going on, Lordship. And my business has completely stopped.
Have you given notice to the?
Yes, we are notice to all the parties. 169 in your Lordship's monthly list.
Probably 30th. It's a PIL, no?
Yes. No, it's not a PIL.
Group
It's not
nine.
it's an appeal, MAT appeal, mandamus appeal.
You verify on what day it can come.
Grateful to your Lordship.
Public interest litigation matter. Normally, your lordship takes it up on Thursdays.
Yes.
Thursday is a holiday.
Yes.
May it appear on?
The next Thursday?
No. On Friday, we'll have some urgencies there. That's what I'm saying. On 24th, Friday.
Friday is original side days. 30th we will take it up.
30th, very well. Can you give it some preference, my lord? Because when I present the matter, I will tell you urgency. I don't want to talk about urgency now. So once the date is fixed, I'll intimate the other side also, the state. Because state largely is being distributed in the manner contrary to law.
No, we list it after fresh cases.
Okay, very
Yes,
good. Because state largest is being handed over to select people contrary to law. Whether this can be done in a civilized society or a country.
You please ask your counsel on record to give the number.
I will give the number on the 30th. I am grateful to your lordship. If your lordship feels some order ought to be passed, otherwise not.
All.
That is a different issue altogether.
My lord, may I be permitted to file this memo of appeal, my lord, without certified copy, my lord, because I have not yet been obtained certified copy, my lord.
Date of the order?
Date of order, my lord, 9th January 2025, and application for certified copy, my lord, 9th, my lord. But, my lord, due to some reasons, my lord, this appeal should be filed, my lord. Kindly give me liberty to, my lord.
Why no? 9th order?
Final order?
9th January.
9th final order process?
Yes, my lord. Final order.
It's a group 9 matter.
Yes, my lord.
Normally it won't take so much time.
My lord, matter is very urgent because, my lord, the appellant is the, my lord, unfortunate prospective adoptive mother, my lord. He wants to take adoption, my lord, a child, my lord, from his friends, my lord. And, my lord, mandate is that, my lord, application should be made on carrying portal, my lord, in the Central Adoption Authority before the, my lord. But, my lord, online application has not been accepted due to, my lord, that the option was given, my lord, home child. But, my lord, your lordship, my lord, I have meant, my lord, the petitioner appellant wants to take adoption from his friend's child, my lord.
So the
And
portal,
offline application has been made, my lord, but that has not been yet been considered, my lord. No response has come from the.
no, in the portal,
Yes, my lord.
there is no such option for other than home child.
Yes, my lord. That's why difficulties has been arise. My lord, kindly
But
take up this matter.
this is covered by a statute. What does the statute say?
My lord, statute, my lord, after statute, my lord, another regulation, my lord, has come, my lord. That is the Kara Adoption Authority, my lord. Regulation of Kara Adoption Authority in the year 2022, my lord. Superseding the regulation of 2017, my lord. And first, my lord, mandate is that, my lord, first applications would be received by the Kara, my lord. In carrying proton, my lord. Unless and until it is received, my lord,
All
no
right.
process is to be, my lord.
What happened to your writ petition?
My lord, writ petition has been dismissed.
On what ground?
Dismissed on the ground that, my lord, application has been accepted by the through online application, but it has not been accepted first. Second, my lord, the order passed, my lord, with the view that, my lord, applications would be made for adoption, my lord, before the juvenile justice board, my lord. But juvenile justice board, 3 criteria was there, my lord. First, abandoned child, second, stranded child, and third, orphan child. These criteria will not be covered by this. This is the main problem, my lord. Kindly, my lord, give me liberty, my lord.
All right.
My lord, I am grateful, my lord.
Lordship, I am praying before your Lordship leave to file an appeal without certified copy with server copy. Order was passed on December 20th by Honorable Justice Amrita Sinha, but till date, certified copy has not been received and has not been delivered. That's why I am filing this appeal and praying your Lordship leave.
Possible within time.
You have applied for the certified
Yes,
copy.
Lordship, and
Annex the photocopy of that application.
yes, Lordship, I will annex. It is with me. I have just to annex with it.
With that and give an undertaking that you will file the certified
Certificate
copy.
within due course of hearing.
Yes.
Yes, Lordship.
All right.
After annexing, I will hand it over before
Yes,
the
leave-
court of
With that undertaking.
obliged, Lordship.
Your Lordship, may I have your kind leave to mention item number 13 of your monthly list, Your Lordship. This is with regard to the unsanctioned apartment was there erected, Your Lordship, and the fire safety is not there, and the competence certificate is not there, Your Lordship. On 30th of August, Your Lordships had heard the matter, and Your
yes.
Lordship has directed to file the report. The KMC has filed the report. Now, Your Lordship, the urgency is that the adjacent building has, in that adjacent building, a fire has been broke out. Now, after that, Your Lordship, the matter has not been taken up. The urgency is that neither.
Let us see how we can do it.
My lord, may I mention, Master Miller, regarding Miller, that prisoners are not protected in the prison, Miller. That the court is sending Miller that prisoner to the prison, Miller, but they are killed by the police, Miller. And in the
But
national
one under trial prisoner killed a police.
police, Miller, the National Police Commission says if any person is
No, one division bench is monitoring this matter. You filed a fresh matter or it's
well, I'm the amicus curiae, but that bench is not sitting today, Miller. And this Miller happened, Miller, last Friday, Miller. And so, Miller, I'm saying,
no,
Miller,
if you want, you file as an amicus, you can file an some supplementary affidavit. You can file a supplementary affidavit. Yes.
my lord, may I permit to mention, my lord, new motion, my lord,
Yes.
of LPA, my lord, letter patent act, my lord.
Please.
My lord, mentioning item number 33 of your lordship's today's list. My lord, the difficulty, I mentioned this matter even the last week. My lord accepted the mentioning. The difficulty is, my lord, it's pertaining to banning of my business to participate in any tenders of Eastern Coalfields Limited. Now, my lord, the banning period is over.
Running the list. Let us see how we proceed today.
My lord, kindly upgrade this because
Make a note.
because
not
the
now.
matter has already become infructuous. The banning period is over. They have still not yet lifted the ban. The new
Item
tender is supposed to
33.
come out in the month of February.
33.
33.
Yes, we have made a note. Let us see.
I'm
Please
so
come.
grateful. my lord.
Appellate side, daily list, serial number 1.
I am for the appellant, my lords.
My lord, I am for the state.
The service is completed.
You can make the correction.
Let this matter be appear next Monday, my lord. Let
Yes.
this matter be next Monday, my lord.
Wednesday, my lord.
Yes.
Monday, I have some difficulty, my lord. Kindly keeps it on Wednesday, subject to my senior schedule.
Grateful.
I'm so grateful.
Serial number 2.
It's my appeal, my lord. Your lordships may kindly take your lordship's order of 23rd June 2023 just for reference, my lord. Your lordship had asked them not to proceed with the contempt, but there is actually no stay of the order.
Lordship, it is a, we are not proceeding with the contempt as per your lordship's direction. We have
But
not.
we are facing one difficulty. The difficulty is that the honorable single judge has been pleased to name one IPS officer with liberty to constitute a team and take over the investigation in which charge sheet has been filed and trials has commenced, my lord. Everything is stayed today, but since there is no stay of the order, the court below is asking for compliance and report from the IPS who has been so engaged.
Which court will the single bench?
No, my lord, the trial court. The trial court says that since there is no stay, Miss Sen, who has been asked to.
Now, have you filed your supplementary affidavit?
Yes, yes. Supplementary affidavit has been
These are
filed.
complete, Lordship. The only thing is that here it's a question of further investigation. The entire trial is being stalled virtually because this investigation, the charge sheets, the cognizance of the charge sheet was earlier taken, and that has been interfered with by the order of the learned single judge. Lordship, kindly come to the order once.
No, I'll place my. I'll place.
Let my learned friend place the order.
That kindly takes my lord page 315 of the stay application.
And the progress report is required to be called for before this court also. That what is the progress of further investigation? Because my fundamental question, which I will be raising, obviously it's not a question of maintainability of the appeal, but whether the state can oppose to a decision where the court has directed one of its competent officer to conduct the further investigation.
My lord, the investigation, my lord, has taken into consideration all the situational circumstances the FIR named accused persons were. Those have been corroborated with other evidence. In the meantime, we have got confessional statement of another person. My lord, the confessional statement has been given in front of a magistrate. My lord, that has also been corroborated by circumstantial other evidences. It is not that an investigation where the entire investigation has been proceeded on the basis only on the confessional statement. Other materials are there, but everything has been disregarded by the Honorable Single Judge. Honorable Single Judge has described our investigation as suspicious, and my lord has not considered these points.
All right. Now, the learned judge has directed fresh or further investigation by which agency?
By one IPS officer who is named in the order, with liberty to her to form a team and then investigate. Because the Honorable Single Judge says that the CID and CBI is already overburdened with several cases. But Malad, that is not the, though it is Malad, she is in our cadre, Malad, that is not the point. The point is that Malad, when the investigation was not perfunctory, without considering the nuances of the investigation, Malad, it could not be transferred at all.
No, you are, no, the learned single bench has recorded certain reasons for that.
Yes, Malad, if I may place the appeal, Malad, I can show that, Malad, it was, Malad, may I place my, if your logic kindly takes from page 99, Malad, it is my notes which I had filed. It is almost like a memo of evidence, just a snapshot of the investigation your lordship will get from there, Malad. Kindly take protocol. And Malad, this was, Malad, though we prosecuted the matter throughout, Malad, this order, final order was passed, Malad, ex parte, Malad. There were some issues going on, Malad, some boycott, etc. was going on, Malad. We could not appear before the court. I had sent my notes before the Honorable Single Judge, which was placed by my learned friend, Malad, and I'm sure pretty fairly. But Malad, from after the matter remaining pending for 5 years, after we appearing throughout.
If the state had not appeared, nothing prevented the state to file a review before the single bench. Now you want to us to test the correctness of the order on the grounds which are not never argued or placed before the single bench.
Well, my difficulty is that the Honorable Single Judge has considered the matter on merit, because as I said, I had filed my written notes. My written notes were before the Honorable Court. My learned friend appearing for the writ petitioner had placed his notes, had also placed my notes. So, Malad, the Honorable Single Judge has proceeded to dispose of the matter on merit. Merit of the matter has been gone into. But, Malad, my case is that the investigation and the points of investigation has not been considered in the right light.
May I place the order once, Lordship? Lordship, this matter was pending. There is a checkered history of this matter. The incident of 2018, just in the eve of the Panchayat election of the state, 2 persons, the lady and the husband and wife, they were burnt alive. That was the allegation. Immediately after this incident happened, that was the Panchayat election going on. Your Lordship knows that how vibrant the Panchayat election season in Bengal is. Lordship, immediately from the very responsible person of the administration, one comment came that this has happened because of the short circuit. So one
Wow.
theory came to give the investigation. Lordship, it would be found from the case diary, if your Lordship may call for that, that initially the police also started to find out that what if there is anything to show that there was the short circuit. Ultimately, one fine day, it was found that CFSL report came that that day there was load shedding in that entire area. So, Lordship, immediately after that, when this entire theory was discarded, immediately after that, this confessional statement, as stated by my learned friend pretty fairly, that came. This person volunteered himself, went to the police station, said that I know so many things. Then this statement under 164 was recorded. And after that, Lordship,
He didn't
this
say.
164 statement was recorded from the person who made the confessional statement. And then, Lordship, the several new names who were not named by the de facto complainant, those names came in the charge sheet. They were shown as the main culprits. The original culprits who were named in the FIR, original FIR, by the de facto complainant, were never been arrested. Nothing happened to them. 41A notice was issued. These are reflected. Then, Lordship, what has happened after that? The new set of persons whose name came, they filed one criminal revisional application challenging that action. Now, that was taken up for a pretty period of time. The entire matter was stayed by the revisional court. And ultimately, our writ was pending. Their CRR was pending. Both were taken up together. They were assigned before the Honorable Single Bench, and matter were taken up. And this judgment has been passed. It's a very peculiar case, Lordship. The set of persons who were named in the FIR, now, after the investigation, for a certain period of that time, they were ultimately discharged. And the persons who were not named in the FIR, who have, according to my case, who have helped this person, were named in the FIR. They brought in the purview of the investigation. So that was the peculiarity which was considered by the single judge, with the help of the case diary and the other progress report submitted by the state. Lordship, it would be found from page 2 onwards, internal page 2 of the order. The formal complaint was filed by the petitioner before the Kagdip police station on 14th May 2018, naming 10 persons: Amit Mondol, Ashok Mondol, Shiva Prasad Mondol, Chandan Giri, Sheikh Monirul, Gokul Jana, Narayan Poti, Meghnad Pakhua, Mohadev Kandar, and Nikunjo Noshkar, and others. These persons are members of the ruling dispensations. Although ingredients of section 302 were clearly disclosed in the complaint, Kagdip police station initially refused to accept the complaint. It is only after pressure from the locals and the complaint was received, but no FIR was registered. The lame excuse given by the state is the police were busy with election duties. It is curious to note that on 15/5/2018, a minister of the state and director general of the police have made public statements that the victim died due to fire caused by short circuit. Such and such, however, points out an endorsement by the superintendent of police, Sundarban Police District, on the complaint to the effect that inquire into the matter, get PO examined by FSL, get postmortem examination done. If any foul play is found, then start specific case over this complaint. At the first glance of the endorsement of the Superintendent of Police, Sundarban Police District, dated 14th May 2018, appears to be innocuous. However, the said endorsement is in direct violation with the dicta of the Honorable Supreme Court in the case of Lalita Kumari versus Uttar Pradesh, Government of Uttar Pradesh, reported in such and such. It was held that FIR ought to be registered immediately when cognizable offence is disclosed in the complaint. The first information report, being number 87 of 2018, was registered. Strangely, only 3 days later, on 17th May 2018. It is equally surprising to notice and fairly admitted by Mr. Bandopadhyay in his notes that notices under section 41A of the Code of Criminal Procedure came to be issued in the FIR under section 436, 302, 201, 34 of the Indian Penal Code. Vital time was lost. The bodies of the victims were, however, sent for postmortem on the next day of the complaint. On 15th May 2018, under HP Coastal, Harur Point Coastal Police Station, UD case number 68 of 2018 and 69 of 2018, both dated 15th May 2018. The first theory that the investigating officer propounds, clearly based on the state minister's public statement and that of the DGP, is the fire occurred due to the electrical short circuit. The opinion of the West Bengal State Electricity Distribution Company Limited was obtained and the case proceeded on that basis. None of the original accused are taken into custody. The statements under section 161 of the Code of Criminal Procedure were recorded sometime in July 2018, that too after orders of this court. The statement under section 164 of the Code of Criminal Procedure of the complaint, who stated in the complaint that he saw the accused persons fleeing away after burning the house, was never ever recorded by the IO. Only a statement under section 164 is recorded. The investigation was proceeding on the basis of the short circuit theory, all the while until 13th August 2018, when the official report was received. The report revealed that the condition of the electrical wire and the bulb recovered from the premises were not due to any electrical short circuit. The wires were burnt and the bulbs had marks the burning due to the external factors which caused the fire. The investigation thereafter took a completely different turn on 14th August 2018. Lordship, kindly consider this date. This date was 13th August. The report came from the official. And 14th August 2018, one Dipankar Mondal alias Deepa came to the IO and stated he was going to the house of one Gurupada Dhara. He found Debu Das and the Bidyut Haldar also present there. Bidyut Haldar, principal accused of the charge sheet, is stated to have threatened Deepa that if he discloses the actual facts, he himself could be murdered. Despite thereof, Deepa, who was silent for 2 months, is stated to have gone into the investigating officer of the case on the same day and had confessed that the real culprit was Bidyut Haldar. The investigating officer of the case made some initial inquiries about the veracity of Deepa's statement and examined his son. What was confirmed was Deepa had in fact gone into the house of Gurupada Dhara and had repaid the loan taken from Deepa. He sent at best a witness to the alleged threats by the said Bidyut Haldar. The very next day, after coming to know where Bidyut Haldar was located and obtaining permission from higher authorities, the investigating officer of the case and a team of police personnel, and Patracheru police station in Sangareddy district of Telangana state conducted the raid and arrested Bidyut Haldar. A transit remand of Bidyut Haldar was obtained and he was brought to Kakdeep in this case and produced before the additional chief judicial magistrate on 20th August 2018. 5 days of police custody was allowed by ACJM. Usual methods of interrogation are stated to have been adopted and Bidyut Haldar is stated to have recorded the confessional statement. In his statement, Bidyut Haldar mentioned the details of the plan of murder of the victims. Such details need not be gone into for the purpose of his decision, except that he has named the following persons: Amar Samanto, Joydev Samanto alias Bhola, Gaur Pradhan, Shukdev Samui, Sukumar Haldar, Chandan Poti, Surojit Haldar, Dilip Mondal, Bidyut Haldar, Kartik Poti, Purnendu Noskor, Sharad Das and Mahadev Samanto as being involved in the crime. This statement of Bidyut Haldar indicates that he instigated and coerced the two accused persons to first strangle with the wife victim to death with a gamcha, commonly used towel. Then they started searching the house of the husband victim, who upon returning to the house a few minutes later was attacked and pinned on the ground. He too was strangled to death with gamcha upon other accused wanting to flee the scene of crime. Bidyut Haldar is stated to have told them that merely killing of victims would not suffice. The house should be burned down. A can of kerosene was procured and the house was set on fire, leaving the victims inside. Based on the above confessional statements, Bidyut Haldar and the persons named by him were charge sheeted. Political enmity was stated to be the motive of the crime. What is most starting here is that the confessional statement of Bidyut Haldar is the direct contradiction with the postmortem report of two victims. The postmortem report indicates that hyoid bone and thyroid cartilage of both the victims were intact. None of the normal medical consequences of strangulation, of compression in the throat area is mentioned. Death is stated have occurred as a consequence of the burn injuries. The bodies were thereafter cremated. The bodies were handed over to the family of the victim by an order passed in this writ petition. Lordship, writ petition was filed when the incident occurred because body was not initially handed over to the boy of the victims, deceased victims. So we had to file a writ petition before this court. By virtue of an interim order, the body was handed over to the victim's son. The bodies were found in Diamond Harbour morgue. The petitioner alleged that the police were not easily forthcoming with the actual location of the bodies. Even if the one ignores the suspicious manner of conduct of the investigation, that is endorsement of the Superintendent of Police, Sundarban Police District, the non-registration of the FIR on receipt of a complaint disclosing a cognizable offence, the delayed registration of the FIR, and the issuance of notices under Section 41A of CRPC in respect of such FIR, what stands out as a clear omission by the investigating officer of the case is that the statement under Section 164 of CRPC of the complainant, who is the son of two victims, was never recorded. The victim had reached the scene of crime immediately and saw the persons named in the FIR flee. He saw the totally and clear eyewitnesses. The reasons for the same remained unexplained. What also transpires from the plain reading of the postmortem report and comparing the same with the confessional statement is that the accused named in the FIR would stand clearly acquitted, as they are completely contradictory. The real culprits are still at large. What remains, however, to be considered is the reasons advanced by the state for not naming any of the original accused complainant in the FIR in the charge sheet. Each of the said persons is supposed to have had a clear, verifiable alibi that they were not present in the scene of crime. It is the fact that requires to be detailed investigation and further examination. In the above circumstances, the court has no hesitation to hold the investigation has been clearly perfunctory. The direction of the investigation might have been altered at the instance of the third persons. The investigating officer of the case may have been acting of such instructions. The charge sheet filed in this case cannot be accepted. In the backdrop of the above, this court is of the view that investigation must be completely reviewed and or reinvestigated or revisited by a senior and responsible officer of the state. Given the number of cases pending with the CID, West Bengal and CBI, this court is not inclined to transfer the investigation to them. This court appoint Ms. Damayanti Sen, an Indian Police Service officer serving in the state of repute, to revisit the investigation and reinvestigate the FIR 87 of 2018 dated 17th May 2018. Ms. Sen, for the aforesaid purpose, shall be entitled to form a team of police or other persons' personals or of her own choice. Ms. Sen may inter alia re-verify the alibis of the persons originally named in the complaint. Such or other persons may be interrogated afresh if necessary. This is merely one suggestion from this court. Ms. Sen shall be entitled to take every steps necessary for the purpose of arriving at the truth behind the murder of two victims. The entire case diary, evidences, statements of witnesses recorded, and all other cases material shall be handed over to Ms. Sen by the investigating officer of the case within a period of 7 days from the date of receipt of the copy of this order. Liberty is reserved for the petitioner to, if the necessary, apply the special public prosecutor or charge of the prosecution agency, change of prosecuting agency after the fresh further and reinvestigation is completed. The impugned charge sheet, being charge sheet number such and such under section 436, 302, 201, 34 of the Indian Penal Code, shall be kept in abeyance. Needless to mention, there shall be no trial in respect of this charge sheet. Ms. Sen and her team may examine the witnesses and record any statements as she may deem necessary. The state is hereby directed to render all and every infrastructure and logistic support to Ms. Sen. If needed, Ms. Sen may seek the assistance of any advocate, including such and such. The court authority may be needed for the investigation. This was the order. Lordship, this order records the reasons why this order was passed. Particularly, this was not passed only after hearing a writ petition, but also hearing one application filed under 482 of the Code of Criminal Procedure before this court, seeking the discharge of these accused persons. So the accused persons, they also.
Now may I place my appeal, Malad? The accused person there said that I am not an accused. That is what that was the contention in the CRR. The accused person says that I am not an accused. Malad, that all the accused will say that I am not an accused. That is not the point, Malad. The point, Malad, if your logic kindly takes my notes, which is almost like a memo of evidence. Malad, kindly, if your logic kindly takes page 99 once, starts from page 99. By individual pages also, Malad, I can place, but if your logic kindly takes
the affidavit in opposition, you have enclosed it along with the supplementary affidavit.
Yes.
Affidavit in opposition.
Yes, yes.
There's a notes also, is it?
Yes, Malad, the notes we had filed before the Honorable Single Judge, not for the purpose of it being the written notes, but we have, Malad, made a very short synopsis of the entire evidence that we collected and the statements that we had recorded. Malad, your Lordship has, my learned friend has been kind enough to read out the order, Malad. Your Lordship will find that nothing of this sort has been discussed in the order.
In the affidavit in opposition, you have not dealt with the statement given by Dipankar Mondal, alias Deepa, before the investigating officer.
Well, Deepa
that
came
appears
to us.
To have weighed in the minds of the learned single bench for
He was produced before the Honorable Single Judge. Deepa's statement was there, placed before the Honorable Single Judge.
In your supplementary affidavit in opposition, you don't deal with that.
But Malad, the CD was produced. The entire CD was produced.
You should at least comment upon it, saying that what happened after the IO recorded the statement of this Deepa.
Malad, may I draw your Lordship's attention, Malad, to one page in the stay application, Malad. Kindly takes 112. 112.
And it's after all your officer, it has not been transferred to.
But my investigation is not perfunctory. But merely because some statements at the initial stage was made regarding a short circuit. Malad, in course of investigation, we have not relied on that statement.
No, that's
we have
not
proceeded on the basis of evidence.
That's not the sole reason for transferring, directing.
The other reason is that the original FIR name accused is not there in the charge sheet. Malad, I asked this question to myself. If merely, without actually investigating the matter, if I put the name of the FIR name accused in the charge sheet, will that make the investigation better? I asked this question to myself. But the purpose of the investigation is to find out the real culprit. The purpose of investigation is not to put the names of the FIR name accused in the charge sheet.
That's true.
But that is the specific finding of the Honorable Single Judge, that my investigation is perfunctory because I have not put the names of the FIR name accused in the charge sheet, and they had appropriate alibi.
Not that. That's not the only reason.
One of the reasons.
Lordship,
confessional statement of this Vidyut Haldar, the learned single bench has found it to be contradiction with the postmortem of the two victims.
Only thing which is contradictory, it is a confessional statement. He said that he saw the two persons being killed by strangulation. The persons, Malad, were not deceased by strangulation. It is his,
so therefore,
his way of thinking.
Why should the state file?
Death was by burning, Malad. Kindly, Malad, takes 112 once. 112. This we have prepared from the CD itself, Malad. But on 14th August 2018, the most vital witness Dipankar Mondal came at the PS and stated that he was suffering fear and did not tell the fact since. The fact is, on the day of the incident, he was going to the house of Gurupada Dhara to loan some rupees, and when he was the nearby house of Debu Das at about 10:30 to 11 hours, he found Vidyut Haldar was present at that place, and seeing Dipankar Mondal, he threatened him that if Deepa disclosed the fact, he will be murdered. Deepa came back to his home. Now, I'm pausing here for a moment. This also came from the confessional statement of this Bidyut Haldar. That when I was leaving the house, I saw Deepa there and I had a word with him. That he said in his confessional statement also. IO also confirmed that the most vital witness, Dipankar Mondal, was fake or not. The IO examined the son of Gurupada and Gurupada was not available, and it came to know that in fact Dipankar Mondal took loan from his father and paid the loan in proper time. Therefore, the loan was also corroborated from the son. IO left for then 15th August, the IO left for Patancheru PS Sangareddy district, Telangana for holding raid, and on 17th August 2018 arrested Bidyut Haldar. Recorded Bidyut's statement under videography, which is converted to a CD cassette. Accused Bidyut forwarded before ACJM Kagdi with 5 days of PC prayer and allowed by learned court. Made reconstruction of the crime scene and by the PC accused Bidyut Haldar under leadership of SDPO so and so under videography. Then prayer submitted before ACJM for recording the confessional statement. Then 27th August, this is important, produced accused Bidyut before ACJM, pleased to pass an order to send accused Bidyut at Diamond Harbour Correctional Home and directed controller DDH for 24-hour segregation period of Bidyut Haldar as he will give confessional statement. Now, after this segregation for 24 hours, then he gave the confessional statement, which is also there at your Lordship's brief at 209. We have filed translated copies of those from the vernacular. Then next recording at 114, Janaki Kandar, aged widow, who is the nearest neighbor of Dipankar Das. She was nearest to the place of occurrence, my lord. She stated that on the day of the incident at night, Dipankar Das shouted beside her window that, "Oh, Thakuma, Thakuma, Oto," like calling her, my lord, for help, that someone is there to kill his father. Hearing this, she went to the house of deceased Debu Das and found the complainant Dipankar Das was crying beside the dead bodies. There was Bhola Samanto and also accused Bidyut Haldar. Seeing Bidyut, the complainant Dipankar Das said that, "Why have you returned?" The complainant said that, "Why have you returned?" making it clear that he saw him before also. Now, why I say this? Well, this comes from the confessional statement also separately, where the person says that when I was leaving, I had met the complainant. And after there was a hue and cry in the village, I went back to the scene of crime. Being asked by Janaki to the complainant, Dipankar Das disclosed to her that when he came at the house, he saw Bidyut. Now, my lord, kindly comes to the confessional statement. 209.
Only one thing, the incident happened in May, and these confessional statement comes in August, June, July, August. My learned friend is referring from 14th of August. What has happened? So far, the FIR named persons in the first FIR, what was the extent of investigation carried against them before accepting the confessional statement? Let them show that.
Yes. Well, kindly, just before taking to the confessional statement, that will be from the synopsis is from page 104 to 101, 111. Just the page prior to from where I started placing, 104 to 111. Well, here the case diary pages are given, but these are also annexed to the stay application. If it is required, I can place it. Can you take from 104? Each and every if I name accused person, we have given. First one was Sheikh Monirul. 14 to 15 persons were together on that day having sort of a picnic, basically consuming alcohol at one place. So they engaged a picnic on the daytime and with the Debudash, incident of Debudash and her wife, when they came to know, they went there. They came to know subsequently. Then I'm reading from 105. Then Ashok Kumar Giri, who is the relative of Debudash, where stated that Sheikh Monirul was present at the picnic which was held at the house of Tapan Mondal with 14 to 15 heads, including Sheikh Monirul. At about so-and-so hours, he got the bad news of the relative Debudash and his wife was so-and-so. Well, these statements are there at 231 and 240 of your Lordship's brief. Then Ashok Giri stated in statement that he received a call from wife's younger so-and-so, this Ashok Giri is same, then Tapan Mondal at 106. He was there, at the picnic at the same time. Then, kindly turns over 107. This is of, this is also the 164 statement of Sheikh Monirul, 107. Then 108 bottom. Horipada Haldar, he was with Joydev Mondal. Then Vishwanath Giri, same as above. Then Chandan Beda. Chandan Beda, kindly sees 109. Chandan Beda, 109. That on 13th May 2018, he was at the reception of his son's wedding ceremony, and his neighbor, Meghnad Dakua, was invited by giving invitation card. Meghnad Dakua went to his house at 2100 hours up to 21:30 hours, and after having dinner, etc. Then Pradeep Koyal also stated in his statement under 161 and 164 that he was invited by Chandan Mera for his son's wedding. He came to the house at around 9:30 up to 10 and enjoyed dinner and so with Meghnad Dakua, and left his house at around for his house at 11:05 p.m. Witness Dut Kumar Noskar was stated that he was at his shop of chocolate and biscuit at Ukilerhat Bazaar, just opposite Gokul Jana. The days of incident of 13 May, he was at Hat Bazaar, that is the wholesale market, and was to gathering by and there was gathering of the customers. On that day, he closed his shop around 10:30 and found Gokul Jana was preparing to close his cloth shop. The distance of the PO to Ukilerhat is 4 to 5 kilometers. Therefore, he was far enough to reach the spot at that point of time. Witness Kunal Das, who have a gift shop as Ukilerhat and so, was also there. These last two are corroborated by each other. The third last and fourth last are corroborated by each other, and all the picnic party has been marked separately. So it is not that, but this is one part. The other part is that all the forensic as far as electric short circuit part has been taken. Whatever is there at the crime scene, if your lordship kindly skips over a few pages, kindly comes to 116. This is the other heading. We had divided our investigation into three parts. One is the part with regard to the FIR name accused. Second part, which I read at the beginning, was with regard to the confessional statement and how it was corroborated by other statements. And 116, the third part, with regard to the seized articles. It starts from 116. The heading is there. Kindly takes 117 onwards. The cloth, soil, burnt mattress, plastic jar containing a bluish liquid like kerosene, so and so has been sent for FSL. The remarks is there, in that right-hand side column. As per FSL report, the flammable like blue dyed substance was kerosene. That report we have obtained. On examination of A, B, C, D, E, F, G, H, I, presence of inflammable higher boiling fraction of kerosene has been detected. One steel-colored mobile set was recovered and seized in the cowshed of the house of complainant Dipankar Das, and the cowshed was adjacent of the veranda of the complainant house. Pausing here for a moment, this was also corroborated in the confessional statement, where he said that someone took the mobile phone from the hand and threw it. Where it fell, he did not say, but he said that the mobile phone was thrown. Bidyut confessed after completing crime scene that he saw Dipankar was coming, and then he threatened Deepa that not to say anybody, otherwise Deepa will be murdered. Now I'm reading the remarks column that this is also matched with the statement of Dipankar Mondal Deepa in his 161 and 164 statement. The postmortem medical legal expert opined in his finding that both deceased had expired 3 hours after last consumed meal. Now the remarks column, it is to prove that the murder probably was committed between 9 p.m. to 12 midnight. But as per statement of a good number of witnesses in their 164 CRPC, it has been established that the FIR name accused Sheikh Monirul was present at the house of one Tapon at Nandamondal, along with the relative of the deceased Debu Das and his wife Usha Rani Das at about 11:30 p.m. As per the statement of Ashok Giri, that is the brother-in-law of the deceased Debu, that he received a call from the wife's younger sister mobile that Debu and his wife has been murdered, which as per CDR, the time is 12:58 a.m. So that CDR is also one of the relevant persons we have obtained to match the statement that they have made. And he returned to the picnic spot and told the fact to Sheikh Monirul, Topon, Joydev, Mondal, Horipodo, Haldar, etc. Then the next one is non-cooperation, because your lordship has found certain allegations against us that we were not handing over the body, etc. That we have, it is not relevant for transfer of investigation in my understanding, but that also we have delineated page 120. The accusation which has been made that we were not handing over the body, it was absolutely otherwise. They intended to have a political rally with the dead body, etc. And that is why they did to make a political scene out of it, They did not take handover of the body. It was the state submission before the Honorable Single Judge at the interim stage that we want to give the body, they are not taking the body. We have annexed those orders also, So it is not true that it was, we did not want to hand over the body or there was any fault in any event, my lord, that is not what I believe has weighed against us with the honorable single judge. But the observation that there was nothing to corroborate and the entire thing proceeded on the basis of the confession statement, but that is an incorrect finding, my lord, in my humble submission. The other points also, my lord, there is one line, if I may point out. My lord, at internal page 6, the honorable single judge recorded at that is page 320 of the stay application, third paragraph, third line. Third paragraph, third line. Such details that in his statement, Bitu Thallar mentioned the details of the plan to murder the victims, such detail need not be gone into for the purpose of the decision. But if that it cannot be, if it is not gone into at all, well, it cannot be seen whether my investigation was perfunctory or not. But what has to be seen is that whether my investigation stood solely on the legs of that confessional statement or not. But if the confessional statement is not gone into, all the corroborative evidence will seem to be immaterial. But what I am trying to canvass, my lord, is that it is not on the basis of a confessional statement alone. And there are several other parts of the investigation which has not been considered in the right light. I understand that there was some difficulty for us to appear. We did not appear. But, my lord, the notes was there, my lord. It is not that we did not prosecute the matter. I have annexed all the orders. Every day we were there. We have assisted the honorable court every single time. But, my lord, though the notes were before the honorable single judge, the CD was before the honorable single judge, the IO was personally present before the honorable single judge, my lord. So it has these findings, along with, my lord, this 321 at the bottom, even if one ignores the suspicious manner of conduct of investigation. But this, the honorable single judge is coming to the conclusion because the FIR name accused has not been charge sheeted. But that is not the question. The question is whether there was enough evidence against the charge sheeted persons or not. Then 322, second paragraph, last line. The real culprits are still at large. But this cannot be determined by the honorable single judge sitting in writ jurisdiction that who the real culprits are. But at least, if this observation is made, the observation, the reasoning ought to have been there that from my CD, who appears to be the real culprits, my lord. Then what remains, however, to be considered is the reasons advised by the state for not naming any of the original accused complainant and the FIR in the charge sheet. Each of the said person is supposed to have a clear, verifiable alibi that they were not present at the scene of crime. Then, my lord, the law laid down here, my lord, in my humble understanding, is that if anyone has an alibi, if the FIR name accused has an alibi, then the investigation is perfunctory. Now, my lord, kindly, my lord, comes back to the confessional statement at 209. Now, this confessional statement, my lord, has to be read with two other statements of Janaki Kandar as well as and Dipankar Mondal, who had came and informed us about Bidyut Haldar. And this confessional statement is before the learned magistrate. The learned magistrate records that there is no coercion, etc. 24 hours has been given to him, whether he wants to make the statement or not. It is not that he came to the, as my learned friend submitted in his summary arguments, that he came to the police station, not so. Someone else came, we had to go somewhere else to arrest this person. This person did not come to us. Kindly take Malad from 209, Malad, the relevant part is starting from 214. Kindly my lord takes from 211. From 10, question number 10 at 211. I am telling you that this confession can be used against you and you can be punished based on your confession. Do you understand this? Yes. Do you still want to confess? Yes. Has anyone beaten you up or pressurized or teach you to make this confession? No. Are you confessing after considering every aspect? Yes. I am repeating myself that you are not bound to make this confession. I honestly want to admit the truth and I have taken everything into consideration. I also understand that if I confess to you, I may be punished. So and so, so and so. I am satisfied that the witness, namely so and so, is not prevented from understanding the meaning and purpose of the questions asked to him or from giving rational and reasonable answers to the same, and hence he is, then my lord, at page 114.
214.
But from 111, thereafter 114. 211. 211 to 214. 214. Competent to make the statement, and so I proceed to record his statement. He is mentally and physically sound in my view. Tell me what you want to say. Joydev Shamunto, Dilip Mahadev, Shukumar took me to drink alcohol. We drank together. The day before the Panchayat polls, he called me and took me to an empty field. Following us, Purnendu, Sharat, Mahadev sat with us in the empty field. 4 of them are so-and-so party workers and I support so-and-so. Joydev told me that so-and-so has been in hold over the Panchayat for 30 years. So you also join us. We will do something big together. I told him I will not be with you. I also told them that I have a previous burn case and I will not be a part of the plan. They all forced me to join them. I said no and went back home. Again that day, around 6:30 p.m. in the evening, I went to Mahadev Shamanto's shop. At that time, Mahadev, Joydev, Panna and others were at the shop. I saw Dilip, Shukumar, Kalipodo were drinking liquor beside the shop. When I went there, Panna asked me, brother, drink alcohol with us. Mahadev said, you are said, will your limbs fall off if you drink so-and-so alcohol? Then Joydev helped me to sit with them. Then Mahadev also joined us. We 4, Mahadev, Dilip, Shukumar and myself drank alcohol together. We drank alcohol for an hour. Then so-and-so party workers came, so-and-so. Then Malad kindly skips over some part, Malad. That part may not be relevant. Then Malad kindly turns over to the next page. 217. 217. I drank a little after drinking. Joydev told me, you come with us, everything is ready. We went along the bank of the lake. He said Shukumar is coming from the other side of the road. We went to Mullapota. After going there, I saw that there are Amor, Shukumar, Gaur, Surajit, Chandan and Kartik. Joydev asked, is all ready? Then I asked Joydev that work was what work you want to do. Joydev said Debu will be killed today. Hearing the same, I was running away. When Amor said I was also running away as I don't want to stay. Joydev said, Amor, you be here and I shall get hold of Bidut. Joydev told me, you just stay, you don't have to do anything, just drink alcohol. I was drinking when Shukdev so and so came. These parts were illegible in the vernacular. Said, if everything is ready, let's go. We all went near Debu's house and Joydev asked Amor to knock down the fence. Saying that, Amor Shamanto knocked down the wall. The wife rushed outside the house to the porch. Amor Shamanto grabbed Bodhi's hand and threw her on the ground. Bodhi asked, why are you doing this? Joydev said that we can't win the polls unless you die tonight. Joydev snatches the mobile from Bodhi's hand and gave it to Amorda. Then Amor choked Bodhi to death. I told Joydev that the job is done. Let's flee. Joydev and Debu should be killed too. Debu was not at home then. For 5 minutes we were there. Chandan Poti stood at the road to stand guard. He said 3 people are coming. Then said 2 people have gone back and 1 is coming. I, Joydev Shamanto and Surajit Haldar stayed outside the house and the rest stayed inside the house. We 3 were standing outside. Coming to the house, Chandan Poti said, grab Debu. Joydev grabbed him and threw him on the floor. Then everyone strangled him with a towel. I then said, let's go as the work has been done. Then Joydev said that no, bring kerosene oil from the house and set the house on fire. Then we fled and Joydev threw the mobile in the forest. I saw Dipankar was coming. Then I told him that if he says anything to anyone, I will kill him. I went back home. When the villagers shouted, I again went towards Debu's house. I was going to fetch water with a bucket when Joydev Shamanto grabbed me and assaulted me and said, you are putting water after alighting the fire. When I told the party people threatened me and said, we will kill you if you say anything to anyone. I was afraid and I went out to work, nothing else. Now, Malad, two other statements are required to be read with this, Malad. Kindly, Malad, take. No, Deepankar. 222. Malad, this is starting from 222. Kindly comes to 226.
Yes.
Well, at the top, your lordship will find the name Deepankar Mondal. This is the person who came to us in August. What do you want to say? I'm a poor man. I was in need of 400, 500 on the day before the polls. Then I went to Gurupada Dhara. I took the money from him many times as loan and I returned it also. At 10 o'clock in the night, I was going on that day before the Panchayat election. When I was going by the side of Debuda's house, then I saw someone in the dark. Suddenly, I found Bidut Haldar was in front of me. He told me, Deepada, you must not tell anyone that you saw me, and if you do, otherwise I shall kill you. Hearing him, it seemed that he had consumed a lot of alcohol. His character was not good in our colony. Many times, me and the neighborhood villagers had beaten him up. He used to bully everyone. After listening to him, I did not go to bring the money, and under fear, I came back home. Later, it was heard that some people had burned Devuda and his wife. I think Bidut Haldar is also involved in all this. Till now, I didn't tell anyone in fear. On 15th August, this is our typographical mistake in making the English. This is 14th August. In the Bengali, it is 14th August. On 14th August, I went to Kagdi PS and told everything to Daroga Babu of Kagdi PS. Now, the other one, the neighbor, kindly takes page 307 at page 310. All the other statements are there, Malad. I am not troubling your losses, Malad, with those. Kindly take 3010. My losses will find the name in the second paragraph, first line, Janaki Kandar. Second paragraph, first line, the name is there. Kindly take 14. A day before the Panchayat election, I went to sleep at 9:30 p.m. at night. Son of Debudas, Deepankar called me, grandmother, please get up. My father and mother has been burnt to death. I woke up and went there and saw that a big crowd had assembled over there. Deepankar was crying. While sitting beside his parents' dead body, Bidut Haldar was present there at that time. After seeing him, Deepankar said in anger, you so-and-so, why have you come here again? One Bhola Shamanto was present at that time. He punched Bidut. I got hold of Deepankar and asked, have you seen anyone? Deepankar replied, I saw Bidut. Now, Malad, your lordships will not find the reference of these vital deposition, Malad, in the order. Malad, without going into these, without going into the other evidence, even prima facie, Malad, even prima facie, I am not saying that it's a trial court, everything has to be gone into by the writ court. But even prima facie, Malad, the Honorable Single Judge did not satisfy itself that appropriate investigation was carried out in the matter. Malad, may I rely on three decisions? Malad?
Not required there. In fact, in your notes, you have relied on two. The learned judge has not referred to any. This intra-court appeal by the state is directed against order dated 16/1/2023 in WPA 6715 of 2018 and CRR number 1199 of 2019. The respondent filed the writ petition.
Lordship is passing the order.
Pardon?
The Lordship is passing the order.
Yes, yes, we have heard. The respondent,
Am I
the writ
required to?
petitioner, had sought for transfer of the investigation relating the case of murder of his parents to the Central Bureau of Investigation, within brackets CBI, to ensure free and fair investigation. The other prayer sought for was to release the bodies of the parents, semicolon, directing the state to pay compensation of rupees 40 lakhs. The criminal revision case in CRR number 1199 of 2019 was filed by the accused in the case registered against them, which was also disposed of by the common impugned order. We have elaborately heard the learned senior standing counsel for the state and the learned advocate appearing for the respondent writ petitioner. Please take your seat. The question is as to whether the learned single bench was right in directing fresh investigation / reinvestigation to be done and nominating a police officer in the cadre of nominating an IPS officer to revisit the investigation and reinvestigate FIR 87 of 2018, dated 17th May 2018. The said IPS officer has been empowered to form a team of police or other persons or personnel of her choice and re-verify the alibis of the persons originally named in the complaint. And such or other persons may be interrogated afresh, if necessary. This, in fact, was a suggestion from the learned writ court. Further, the learned writ court observed that the named officer shall be entitled to take all and every steps necessary for the purpose of arriving at the truth behind the murder of the two victims. The state is on appeal against the said order by contending that the observations made by the learned single bench that the investigation was perfunctory and it did not meet the normal standards of investigation, and therefore the matter has to be reinvestigated is not borne out by records. And in this regard, the learned senior standing counsel elaborately referred to the statements of the various witnesses, accused, etc., which were recorded before the learned judicial magistrate. In this appeal, we are required to see as to whether the learned single bench had recorded reasons as to why and for what purpose reinvestigation had to be ordered. If the view expressed by the learned single bench to arrive at the ultimate conclusion and ordering reinvestigation satisfies the test of reasonableness, this court will refrain from interfering with this said order. If the court has to examine threadbare the statements of various witnesses at this stage of the matter, it would tantamount to expressing an opinion in the case, and the very purpose for ordering reinvestigation would stand defeated. Therefore, we are required to see as to whether the prima facie view expressed by the learned single bench in the impugned order would justify the direction issue. The learned single bench, it is to be pointed out that when the writ petition and the civil revision case was heard by the learned single bench, the state was not represented. However, the affidavit in opposition filed by the state and the written notes submitted by the investigation officer were part of record, which has been taken note of by the learned single bench. The parents of the writ petitioner were murdered who belonged to a particular political party. The panchayat elections in the state was scheduled to be held in May 2018, and a day before the election, that is on 13th May 2018, the parents of the writ petitioner were killed and the house was burned down. A complaint was lodged by the writ petitioner before the Kakdeep police station on 14th May 2018, naming 10 persons. It appears that initially the said police refused to accept the complaint, and only after pressure from locals the complaint was received, but no FIR was registered. The learned single bench notes that non-registration of FIR, that the state, learned single judge noted that the state came with the plea that these police were busy in the election duties, and therefore FIR was not registered, to be a lame excuse. On 15/5/2018, a minister of the state as well as the Director General of Police are stated to have made a public statement that the victims died due to fire caused by short circuit. The writ petitioner pointed out that an endorsement was made by the Superintendent of Police, Sundarban Police District on the complaint to the effect that, inverted comma open, inquire into the matter, full stop, get PO examined by FSL, full stop, get postmortem examination done, full stop. If any foul play is found, then start specific case over this complaint, inverted comma close. The learned single bench found that this endorsement was in violation of the judgment of the Honorable Supreme Court in Lalita Kumari vs. Government of Uttar Pradesh, 2014, 2 ACC, page 1, wherein it has been held that FIR should be registered immediately when a cognizable offence is disclosed in the complaint. Ultimately, FIR was registered after 3 days on 17th May 2018 in FIR number 87 of 2018. The state in their written notes had accepted the fact that notices under section 41 capital A of the Code of Criminal Procedure came to be issued in an FIR under sections 436, 302, 201, read with section 34 IPC. The time lost between the date of occurrence and the date on which the FIR was registered, was a very vital issue, and this was rightly noted by the learned single bench that the vital time was lost. The bodies of the victims were sent for postmortem on 15th May 2018. Full stop. The initial theory, as stated by the investigating officer, is that fire occurred due to electrical short circuit. And in this regard, opinion from the West Bengal State Electricity Distribution Company Limited is stated to have been obtained. The learned single bench points out that none of the original accused were taken into custody, and their statements under section 161 of the Code of Criminal Procedure were recorded during July 2018 after orders were passed after directions were issued in the writ petition. The learned single bench notes that the statement under section 164 of the code of the complainant, who's stated in the complaint that he saw the accused person fleeing away after burning the house, was never recorded by the investigating officer, and only a statement under section 164 is recorded. Thus, the learned single bench found that the investigation proceeded on the basis of a short circuit theory until 13th August 2018, when the FSL report was received. The report revealed that the electrical wire and the bulb recovered from the premises were not due to electrical short circuits, and the wires were burned and the bulbs had marks of burning due to external factors which caused the fire. One vital issue which weighed in the mind of the learned single bench is a statement given by one Dipankar Mondal alias DIPA before the investigating officer on 14th August 2018. And that he was going to the house of one Gurupada Dara, and he found Debudas and one Vidyut Haldar were also present there. And the Vidyut Haldar, who is the principal accused in the charge sheet, is stated to have threatened Deepa that if he discloses the actual facts, he would also be murdered. After remaining silent for quite some time, the said Deepa went to the investigating officer and confessed that and stated that the real culprit was Vidyut Haldar. This the learned single bench, after going through the contents of Deepa's statement, opined that he was the best witness to the alleged threats by said Vidyut Haldar. By then, Vidyut Haldar had gone missing, and ultimately he was located and arrested in the state of Telangana and was brought to Kakdeep and produced before the additional chief judicial magistrate on 20th August 2018, and 5 days police custody was allowed. In the statement given by Vidyut Haldar, details of the plan to murder the victims were stated to have been given. And this according to the learned single bench, need not be gone into for taking a decision in the writ petition. However, in page 6 of the impugned order, the learned single bench has noted the names of the persons who were involved in the crime. The learned senior standing counsel for the state would submit that the learned single bench could not have made an observation that that details need not be gone into for the purpose of the decision, except that Vidyut Haldar had named certain persons. And if such was the finding of the learned single bench, the writ petition could not have been disposed of by nominating an officer to reinvestigate the matter. In our opinion, the observations of the learned single bench that details need not be gone into for the purpose of a decision in the writ petition is well justified, since at this stage of the matter, if any opinion is expressed by writ court, which took a decision based on affidavits, it would be expressing an opinion in the matter, and ultimately not only prejudice the rights of the complainant, but also that of the alleged accused. The learned single bench has noted that the statement of Vidyut Haldar indicates that he instigated and coerced two accused persons to first strangle the victim wife to death with a towel, and they started searching the house of the husband victim, who upon returning to his house a few minutes later was attacked and pinned on the ground, and he was also strangled to death with a towel. The single bench noted that Vidyut Haldar is stated to have told them that mere killing the victims would not suffice and the house should be burned down, and a can of kerosene was procured and the house was set on fire, leaving the victims inside. After noting the statement of Vidyut Haldar, the learned single bench expressed a prima facie opinion that his confessional statement is in direct contradiction with the post-mortem report of the two victims, as the post-mortem report indicates that the hyoid bone and thyroid cartilage of both the victims were intact. The bodies of the victims were cremated. After the bodies of the victim were handed over to the writ petitioner's son after interim direction was issued in the writ petition, and it was cremated. The learned single bench has commented upon the endorsement made by the Superintendent of Police, Sundarban Police District, the non-registration of FIR on receipt of a complaint disclosing a cognizable offence, the delayed registration of the FIR and issuance of notices under Section 41 capital A in respect of such FIR would stand out as clear omission by the investigating officer of the case is that the statement under Section 164 CRPC of the complaint, who is the son of the victim, was never recorded. The learned single bench further made a prima facie observation that the victim had reached the scene of that he was only and a clear eyewitness. The learned single bench also commented upon the reason for not naming any of the original accused in the complaint and FIR and in the charge sheet, despite clear verifiable alibi that they were not present. FIR, full stop. Therefore, this led to the forming of an opinion by the learned single bench that the matter requires detailed investigation and further examination. As noted above, the prayer sought for by the writ petitioner was to transfer the investigation to a central agency, namely CBI. This prayer was not granted by the learned single bench, taking note of the fact that several cases are pending with the CBI as well as with the CID, West Bengal, and therefore the learned writ court thought fit to appoint an officer, a named officer, who's an Indian police service officer serving the state of West Bengal, to revisit the investigation and reinvestigate the FIR number 87 of 2018. The said officer has been given a free hand by the learned single bench, giving liberty to form a team of officers or other persons and to re-verify the alibis of the persons originally named in the complaint and such other persons who in the opinion of the officer are to be interrogated afresh. The learned single bench has carefully worded the observations and observed that these are mere suggestions from the court. Full stop. In our opinion, the learned single bench was fully justified in not issuing any positive direction, as it would tantamount to telling the officer nominated to reinvestigate to proceed in a particular fashion, which seldom the Red Court does. This observation of the learned single bench also stands fortified by the observation that the said officer shall be entitled to take all and every step necessary for the purpose of arriving at the truth behind the murder of the two victims. Thus, in our view, it is not a case where the learned single bench did not form an opinion as to why the matter requires to be reinvestigated by a state level officer who has been specifically named in the complaint, giving all liberty which are available under law, so that the officer can proceed to reinvestigate the matter for the purpose of arriving at the truth. Thus, in our view, the direction issue cannot be faulted, and the reasons which the learned single bench has recorded for issuing such direction cannot be said to be wholly unreasonable for this court to interfere in this intra-court appeal. Thus, for the above reasons, we find no grounds to interfere with the impugned order, and accordingly, the appeal is dismissed. The entire case diary, evidences, statements of witnesses recorded, and all other case materials shall be handed over to the officer who has been nominated to reinvestigate matter within a period of 3 days from the date of receipt of the server copy of this order. We make it clear that the observations which ultimately led to the direction issued by the learned single bench is to justify the need for fresh/further/reinvestigation, and such opinion recorded cannot be construed to be any opinion on the merits of the matter, for which the officer has been given free hand to take all and every step necessary for the purpose of arriving at the truth behind the murder of the two victims. Dismissed.
Grateful, my lord.
Next.
Serial number 3.
I'm appearing for the petition.
I'm for the respondent number 6.
As for respondent number 5.
Paper book. Will admit or cannot admit.
For better understanding of the case, I have prepared a list of dates. I'm serving copy upon my learned friends. But before my learned senior friend starts, there's an issue of determination. This writ petition concerns labor. This has been filed in group 9.
Probably not.
Very well. That's why learned friends.
Probably not. It was misconstrued and the writ petition was dismissed. What happened, in this matter? The petitioners are the landowners, and as per the Trans Damodar in 2000, kindly comes to a list of dates. In 2003, a memo was issued for identification of coal land. In 2005, cabinet approved acquisition of 97 acres of land. In 2008, rehabilitation proposal was made. 2010, Trans Damodar project was set up. Petitioner, being the land losers, got job in the particular area. Subsequently, what happened, my lord? Subsequently, time progressed. They were working. In 2014, the order of the Honorable Supreme Court regarding deallocation came. Coal bearing app came, all the coal blocks were deallocated, re-auctioned, and in the DPL, Durgapur Project Limited came into the picture. What happened after that, Durgapur Project Limited wanted the petitioner to sign one agreement stating that they will put the petitioner's appellant under a third party as a contract labor. My point is, I am the land loser, my lord. I was working, I have given my land was taken. By this time, project was changed, the ownership, my mining company was changed. I was trained skilled labor, and they wanted to put me under unskilled labor under a third party. I was a direct employee of Trans Damodar Project Limited. For the last 100 months, my lord, I am not getting any salary. For the last 100 months, I'm not getting salary. They are not giving the PF dues, and no process are they following. This is the sum and substance of the case.
When the Honorable Supreme Court cancelled the coal block allocation and
Reallocated to us.
how do you say that in the new company to
Yes.
whom it was allotted, the same package will apply?
Kindly visualize my
Are you carrying the Supreme Court judgment? Is there any
right now? Right now,
observation?
my lord, it was kindly visualize. Admittedly, this is my land. Admittedly, this was my land, not this is my land. This was my land. Our agreement was signed by all the parties. I have annexed the agreement, and as per the agreement, man currently comes to.
No. See, if let us assume originally it was allotted in favor of
Trans Damodar
coal project. If the Trans Damodar coal project had merged with Durgapur Projects Limited, you can still say it's the same entity. By operation of law, now DPL has come into existence. But here in 2014, the original coal block allocations were all cancelled.
Yes, madam.
Fresh exercise was required to be done. But is there any observation made by the Honorable Supreme Court?
But Honorable Supreme Court did not interfere. So far my knowledge, I will come with the judgment on the next occasion regarding the employment. Only the allotee was changed. Only the allotee was changed after auction.
After the land was acquired, all of them were given compensation
and job. That was
as a part of a resettlement package. One family member will be given the job in the project. So the basis is the allocation by the state. That allocation stood cancelled. What is the consequence or effect of such cancellation?
Land was taken
on this resettlement. The rehabilitation, resettlement, compensation is one thing, rehabilitation, resettlement. So rehabilitate and resettle means you give a job to that person was working. So if the company has lost its right on the coal block allocation, how do you enforce this resettlement package on a successor who got this allocation pursuant to a fresh auction?
My lord, that subject to correction, my lord, that land was.
You should have intervened in the Supreme Court. Yes. You should have intervened.
But I will come with the judgment of the passed by the Honorable Supreme Court.
You carefully read the judgment.
Yes, my lord.
Whether any protection has been. See, otherwise, what happens is.
Right now, I am not carrying, man. I have gone through the judgment.
That is one. Number two, when the fresh allotment was directed to be done, notification would have been issued. In that notification, is there a condition that whatever was a resettlement package was given earlier will be binding upon the successor entry of the fresh company who may be allotted?
But subject to correction, right now I am not carrying, but so
you
far
have to work on that.
So far I can recollect, my lord. I was appearing for the coal bearing authority before this Honorable High Court in different matters. So far during that transition period, so far I can recollect some protection was given. Let me give some time. I will come with the judgment.
So otherwise, what happens is essentially a labor dispute.
Yes.
Essentially a labor dispute. So probably you can initiate conciliation proceeding going before the Commissioner of Labor or Regional Commissioner. Conciliation fails, you can always raise a dispute saying that I have to be, because the compensation you have not paid back. Whatever monetary compensation, solatium, interest, you are still retaining. Now you want this resettlement package to be implemented.
Subject to correction, my lord. Compensation includes the job, my lord, subject to correction.
This was under which enactment? This was under the
Old
Land
Act.
Acquisition Act, 1894.
Old Act.
Old Act.
But
Old Act does not contemplate resettlement rehabilitation. That is only in the present
but
Act.
subject to correction, there are some protection. I will come back on the next Monday
You
with the
have to
judgment.
work on that direction.
I will come back on the next Monday, my lord. Kindly be pleased.
Or what you should have done is you should have intervened in the Supreme Court.
Yes.
That mistake you did.
Yes.
My lord, all
And the one condition could have been added in the fresh notification saying that whatever resettlement rehabilitation package was given to the land losers
That should be.
by the Trans Damodar coal will equally apply mutandis to the new entry. Otherwise, you are trying to put him on a condition to which he never agreed.
Naturally.
Or you read the notification carefully, read the entire Supreme Court. There are various directions issued. It is not a single order. My recollection is
Yes.
not a single order.
yes, ma'am.
Various stage they were monitoring the matter. Then at one stage they said everything is
Everything.
illegal, gone. So obviously Supreme Court would have been apprised of the fact that by now so many people have been given employment. What will happen to their rights?
So far I can recollect, but there was some protection. I will come back with the judgment, ma'am. I will come back with the judgment.
We have heard the learned advocates for the parties. The first issue that the appellant should address this court is whether the terms and conditions of terms and conditions which are part of the coal block allocation in favor of Trans Damodar project could be applied to the new entity, namely Durgapur Projects Limited, who became the successful allottee after the earlier coal block allocation. The earlier coal block allocations were cancelled by the cancelled pursuant to the orders passed by the Honorable Supreme Court. The second aspect that the appellant should be able to satisfy this court is that whether the terms and conditions of the rehabilitation and resettlement package, which was approved when the coal block was allotted in favor of Trans Damodar coal project, would continue to hold good despite the fact such allocation was cancelled and fresh allocation and fresh notification was issued, pursuant to which the Durgapur Projects Limited was allotted the coal block. The third aspect is whether in a writ petition the appellant can seek to enforce the terms and conditions of a rehabilitation and resettlement package entered into, notified by Transborder the coal project, Que Durgapur Projects Limited. If all the above issues, assuming all the above issues are answered in favor of the appellant, yet as to whether a writ court can issue any direction as prima facie it appears that the issue concerns employment and would fall within the broad spectrum of a labor matter. Full stop. The learned advocate appearing for the appellant seeks time to examine these aspects, go through the various orders and directions and the judgment of the Honorable Supreme Court and make submissions. List on so. February. Great. Yes. Definitely there will be some observation.
There are, my lord. So far I can declare there are.
Ask your juniors to work on that.
And I will personally work out on it.
And every stage they were passing orders. Both this one and the petrol pump allotment. Yes. That was also cancelled. Pan India. There was the series of orders were passed. Next.
Serial number 4.
My lord, I am for the petitioner, my lord.
I am appearing on behalf of the state.
My lord, here my lord, petitioner number 1, petitioner, he's the only petitioner, my lord. He was the head of the department ENT Calcutta Medical College. Now he retired, my lord. And my lord, the petition opposite party number, respondent number 3, he was the superintendent, vice principal of the state college. My lord, the respondent number 2, my lord, she has filed an application before the State Consumer Forum for compensation for the sad demise of her husband. Now, my lord, the state commission, my lord, passed order ex parte, my lord, that was due to laches of the petitioner and also the respondent number 3, my lord. Ex parte order of passed, my lord, and award was passed for the sum of rupees 10 lakhs, my lord. Jointly and severally. Now, my lord, after getting a notice of execution, my lord, the petitioner number 1, both are appear, my lord, petitioner number 1 and the respondent number 3, because those the two are judgment debtors, my lord. Petitioner submitted that he is ready and willing to pay his proportionate share of liability, that is 5 lakhs.
But why did you not file an appeal against the
My
award?
lord, get the notice at a later stage, my lord. Get the notice at a later stage, my lord.
You could have filed it along with the contemporary application.
Yes.
Well,
Once it's jointly and severally, how do we split the award?
My lord, I am telling you, if you can see the
If they are willing to accept
order passed by
Section 58 of the Consumer Protection Act, there is a provision of appeal.
You
well,
should
the
have filed
appeal was there, my lord, but at this time, my lord, I instead of preferring the appeal, my lord, I want to make compensation to the bereaved family. To the bereaved family, my lord, because my lord, if you can see the order passed by the Lane.
That is a concession if the writ petitioner agrees. I'm sorry, if the applicant before the consumer forum agrees to accept 5 lakhs from you and discharge you from the liability right. As a writ court, we can't compel. How do we split the award?
What has happened, my lord? If you can see the order passed.
Assuming there are 2 people who have been made liable. One becomes insolvent, let us say. Then, because the decree is, award is joint and severally liable, the complainant, he can enforce it against the surviving debtor.
My lord, another thing your lordship can see, my lord, the respondent number 3, my lord, they prefer an appeal before the learned National Consumer Forum, my lord.
For enhancement.
No, my lord, respondent number 3, that is the superintendent cum principal. My lord, he's also the another judgment debtor. He filed an application appeal before the learned National Forum. My lord, that was dismissed. My lord, against that, they filed an application for review. Review application, that was also dismissed.
Supreme Court.
No, my lord, they filed an application before, papered an appeal before the Delhi High Court, my lord, Honorable Delhi High Court. Delhi High Court stated that we have no jurisdiction to entertain this matter.
Even Calcutta High Court doesn't.
Calcutta High Court, and they have filed an application under 227. My lord, that is pending, my lord. I have no knowledge. I have not got the details of that because, my lord, I am.
227 is not maintainable. Sir, it's a code by itself, Consumer Protection Act.
Yes.
So the hierarchy is that.
Yes, my lord.
I have not. Forum,
my lord, only my prayer before your lordship, my lord.
National Commission and then Supreme.
Yes, my lord. My lord, that is true, but they have not exhausted that remedy, my lord. My lord, they have not exhausted. I have not preferred any appeal. The
best thing is you call the second respondent, Uma Mondal, and convince her to accept this and give you a clean sheet.
My lord, your lordship, my lord, your lordship can see the observation of the honorable single judge is the amount cannot be bifurcated.
Exactly so.
My lord, if they exhaust their remedy, if they bifurcate their remedies, my lord, I can also bifurcate my liabilities also. My lord, they bifurcate their remedies. My lord, they prefer appeal before the honorable National Forum. Then, my lord, file application for review individually.
Assuming your client had remained ex parte right through.
Yes.
And your client is not traceable. The complainant before the commission can recover the entire money from the superintendent of the hospital. Entire 10 lakhs with interest. Equally so, same principle.
My lord, if you logically consider, my lord, jointly or separately, so far as gathered from the dictionary, my lord, if anyone is unable to pay, my lord, other is liable to pay. My lord, state, my lord, you logically see, state cannot say that they are not unable to pay because they prefer appeal before the
All right,
consumer
now,
court. They have exhausted more amount, my lord.
No, has she filed an execution?
Yes.
It is pending before the
Yes,
commission.
yes, yes.
You go before the commission, make this offer.
My lord, I have made this offer, my lord. That is before you, lord.
Go before the commission, sir, not in the writ petition.
No, my lord. Before the commission, I made this offer, my lord. If you lordship kindly come to, my lord, I am coming, my lord.
And what is the order passed by the commission?
Yes, yes, my lord. Page 36, my lord. Page 36, your lordship. Running page 36.
A petition is not available. What is page 36?
My lord, just a minute.
26,
26, let's see, that's 36. 36 or 37, no, 37, page 37, sorry, my lord.
You don't have the stay petition, sir. Only
There is
memo.
no stay petition, even my lord,
My lord, stay
the
petition.
impugned order has not been.
You read what is 37.
My lord, may I read, my lord? My lord, I filed the stay petition and mentioned the matter.
All right.
Degree holder is present through learned advocate. Mr. Shopon.
Read.
Mr. Shopon Pal, learned advocate, appears on behalf of judgment data number 2 by filing Vokalatnama. Let the Vokalatnama be kept in the record. Mr. Mukul Kumar Mitro, learned advocate, appears on behalf of the judgment data number 1, who is the petitioner before the lordship, my lord, by filing Vokalatnama. Let the Vokalatnama be kept in the record. Heard the learned advocates appearing for the parties. The learned advocate appearing for the judgment data number 1 submits that the judgment data number 1 has complied with the order dated 9/2022 passed by this commission, and as such he has prayed for an adjournment for making payment of the 50% of the digrital amount. Permission is sought for cannot be allowed as the OP is directed jointly and severally to pay the company compensation of rupees 10 lakhs to the complainant within 30 days from the date of the passing of this order, that is on such and such date. The learned advocate for the judgment data number 2 submits that this commission, that the judgment data number 2 will prepare an appeal before the Honorable National Commission against the order dated 2/9/2022 passed by this commission. As such, he has prayed for an adjournment for bringing stay order from the Honorable National Commission. Prayer of number 2J, judgment data is considered and allowed. 16/8/2023 for bringing stay order from the Honorable National Commission in default compliance of the order passed by this commission. Well, commission was imposed 2 or 3 occasions cost upon the judgment data number 2. And last occasion 17th was.
Could have carried on this order on appeal to the National Commission and then made this offer before the National Commission. There are good chances the commission might have convinced.
Because my lord, your lordship can say this is the order dated 21st June 2023.
You could not have challenged, sir. You will learn at single bench records that identical prayer you have made before in the writ petition. How is it is maintainable?
Well, identical prayer, yes, my lord. My lord, before I lost that, I prepared the writ petition. Not that, my lord, simultaneously.
Writ is not maintainable. Our sympathies to you, what to do.
My lord, your lordship can see, they bifurcate their remedies. They bifurcate, they went individual to the different forums.
The writ petitioner is the appellant in this intra-court appeal, being aggrieved by the dismissal of the writ petition by the impugned order. The matter arises under the provisions of the Consumer Protection Act. The second respondent herein filed a complaint before the State Consumer Disputes Redressal Commission, West Bengal, claiming compensation of rupees 10 lakhs for the death of her husband. The respondents / opposite party before the commission were the appellant herein and the superintendent cum vice principal, Medical College, College Street, PS Bow Bazaar, Kolkata 12. The State Commission had awarded a compensation of rupees 10 lakhs, making both the opposite parties, namely the appellant and the superintendent cum vice principal, Medical College, as jointly and severally liable to pay the compensation amount. The appellant did not challenge the order passed by the State Commission by filing an appeal before the National Commission.
Well, I have not prepared appeal before the National Commission.
No, that's the the superintendent,
Respondent number 3, my lord, subject to correction.
superintendent cum vice principal of the medical college is stated to have preferred an appeal before the National Commission, which was dismissed, which was and the said order was challenged before the Delhi High Court, and the writ petition was dismissed as not maintainable. In the execution petition, the appellant contended execution petition filed before the State Commission. The appellant had contended that he is ready and willing to pay us 50% of the award amount, namely rupees 5 lakhs. This prayer has been rejected by the State Commission and such orders become final. Parallelly, the present writ petition was filed with an identical prayer. The provisions of the
No, but I have
Consumer
not filed it
Protection Act
parallelly, my
is a
lord.
self-contained code,
After
and
rejection of
it
the
provides for the hierarchy of remedies. And therefore, a writ petition would not be maintainable to challenge an award passed by the State Commission, nor to bifurcate the award into two. Therefore, the learned single bench was right in dismissing the writ petition. However, hence no grounds have been made to interfere with the impugned order. However, it is well open to the appellant to discuss with the second respondent herein and work out an amicable settlement. Next.
My lord, may I submit only one thing, my lord?
Hmm.
Only one thing, my lord. My lord, my intention was to help the bereaved family. Only that is my intention. Otherwise, my lord,
Call
when it
them-
will be finalized.
You call the other side advocate to your chamber, their client, your client.
My lord, may I submit, my lord, if you lordship can adjourn this matter, I shall give a notice to the respondent number 2, so that he can submit before the lordship.
You ask
The
your
matter
client,
can be settled by the lordship.
you please act as a mediator. Next.
No, my
Serial
lord.
number 5.
Sorry, sir.
That's my appeal, Lord.
My
It's
lordship.
a matter where information has been sought from me, which
My
is
lordship.
after 13 years.
Yes.
My lord, dear lordship had
Sparing time for on behalf of the petitioner due to his illness. Yes,
my lord, dear lordship had
got heavy fever.
given me liberty to pray for deferment before the honorable single judge. We had prayed so. The matter has been kept on 31st of January, which is the deferment which has been granted to me. But there is again, my lord, there is no stay of the order, my lord. So
We have heard the senior standing counsel for the appellant to stop. On behalf of the respondent who was appearing in person, adjournment is sought for on the ground of his personal inconvenience. The learned senior standing counsel submitted that the contempt proceedings, the hearing of the contempt proceedings have been deferred, and the next date is 31st
of January 25.
January 2025. Since we have framed the legal question to be considered in this appeal, namely as to whether the prayers sought for in query numbers A and B would qualify as information to be furnished under the provisions of the Right to Information Act. We have also observed in our order dated 15/1/2025 that the information sought for in queries C, D, E and F are not in the nature of a query seeking for information, and as the writ petitioner seeks for a detailed inquiry to be conducted by the Directorate of Anti-Corruption Bureau under the Government of West Bengal /CBA.
and para 10 of that order, para 10.
Certain other observations were also made in our earlier order dated 15/1/2025 while condoning the delay in filing the appeal. Since the appeal is adjourned and a request made on behalf of the respondent, writ petitioner, list the contempt proceedings pending before the learned single bench shall remain stayed till this appeal is heard and disposed of. And and let this appeal be listed on so. Next.
Serial number 6.
Six.
I'm for the appellate. Now, a few days back when I have been briefed, but I found that this application should be moved before the Lord Bank Tribunal. It is not maintainable here, in my view, though I have been briefed for the appellate. So, what I am praying, Lord, subject to sanction, I am withdrawing it, allowing me not to file within a particular time, Lord. Tribunal.
In fact, that is what is observed by the single bench.
Yes, that I told my client.
Correct.
Who has been briefed.
Correct advice. The learned, we have heard so and so. This interpreted appeal by the writ petitioner is directed against the order dated 26/20/24 in WPA 159555 of 2024. The learned single bench, after considering the prayer sought for, has observed that the remedy for the appellant writ petitioner is before the Debt Recovery Tribunal under the provisions of the Sarfasi Act 2002. Since the Bank of Baroda has obtained an order under section 14 of the Act in the year 2012 and in the year 2016. The learned advocate appearing for the appellant submitted that he is also convinced that the appellant should approach the Debt Recovery Tribunal. Thus, we find no grounds to interfere with the impugned order. However, as observed by the learned single bench, liberty is granted to the appellant to approach the Debts Recovery Tribunal for appropriate relief.
No, within a particular time, maybe.
Subject to transaction.
No, within a particular time, that I am requesting. Because otherwise it will be brought by.
If an application is filed, the Debt Recovery Tribunal may exclude the period during which the writ petition was pending as well as this appeal while computing limitation. Next.
Serial number 7.
May I file affidavit of service?
Affidavit of service taken on.
Lordship. I find that after court judgment, we have no scope.
Bali Municipality. You have informed Mr. Ian Bennett.
I have informed. Last order has duly been complied with.
Very good. And who will appear for Bali Municipality?
I have served notice upon Mr. Mohan Banerjee and also upon the learned advocate who appears for the state in before the Reed Court.
But my lord, sir, there are two aspects to it. One is the right over the property. Rightly, the learned single bench said that title suit is pending. Even assuming that is pending, can he run a cattle shed without license? No, that he can't. So we will direct the Bali Municipality.
That is why, may I tell? After the order passed by the learned single judge against which the appeal has been prepared before your lordship, now, my lord, since the appeal has been prepared and my lord, the police authorities and other departments, they have been implicated as party respondent. But normally, my lord, they have to, but they have to take steps to inquire the matter. At least a police report. Now, my lord, here, my lord, it appears that, my lord, there is a under the report. Now, my lord, kindly have a look, my lord. And this is, my lord, there is the date of 10th September 2024. Sorry. দেখি কপি দিয়েছে আপনাকে আমি হ্যান্ড ওভার করে দিচ্ছি এক সেকেন্ড my lord kindly come to the third paragraph of the report. In this regard, on 6th March 2024, a joint inspection of the said unauthorized cattle have been done by the concerned authorities, that is Dr. Bhaskar Maji, AD ARD Howrah, Dr. Debashish Chatterjee of Cattle Licensing Authority. After completion of inspection, the concerned authorities directed to private respondent number 9 for immediate removal of the calf from said unauthorized cattle, failing which action will be taken. On 10th September 24, SI visited the spot and found there are no cattle, but the tarpaulin shed is still there and photo are annexed herewith.
So
Pathetic
let the police direct him to remove the tarpaulin shed also.
But I leave it to
Because otherwise,
unless-
after
yes,
10 days,
yes,
once
then
again
again,
they'll bring.
yes, yes.
Actually, that has been happened. If you look, I am having the copy of plaint also. When the suit was filed, there was no business running over there. After, when I obtained the civil status quo order, then started.
The writ petitioner.
Malana is appearing for Bali municipality.
You also inspect, madam. He is running a
Yes.
cattle shed without license.
Under the municipality, yes.
See, it will cause lot of nuisance, unhygienic condition, etc. You also send one officer to inspect. The appellant is the writ petitioner. Agreed by the impugned order, by which the prayer sought for in the writ petition was not granted, but liberty was granted to the appellant to approach the civil court with all the prayers. The matter concerns, no, the appellant alleges that the private respondent is illegally running a cattle shed in the adjacent property. It is not in dispute that there is a suit pending in respect to the property, namely title suit number 16448 of 2014 before the learned civil judge within bracket junior division, 6th court at Howrah for recovery of possession of the property from the private respondents. Therefore, the learned single bench. Now, further in the civil suit, there is an order of status quo.
I'm having the copy. If you look on record.
Status quo has been passed. The grievance of the appellant is that the private respondent is illegally operating a cow shed without obtaining requisite license from the Bali municipality or other authorities. The Learned Government Council has received written instructions from the Inspector of Police and IC Liluha, Liluah, Police Station, Howrah, dated 10th September 2024, in which the following has been stated. In which, among other things, the following.
The report signed by 3 persons, the second page of the report. Sub Inspector, Liluah Police Station, AD, ARD, Howrah, and then Cattle Licensing Authority also.
Report,
Joint
dated,
inspection. Joint inspection report.
Enclosing the joint inspection report conducted by inspection report drawn pursuant to inspection done by the Cattle Licensing Authority, AD, ARD within bracket SA Howrah, and Sub Inspector Liluah Police Station. On 6/3/2024. So, wherein it has been stated as follows. The Inspector of Police, Liluah Police Station, has given written instruction to the Learned Government Council, wherein the following has been stated. Thus, it could be seen from the above report, the cattle have been removed, but the shed continues, tarpaulin shed continues to remain. Therefore, we direct the authorities of the Bali municipality as well as the authority, the authorized cattle licensing authority officer and the inspector of police, officer in charge, Liluah Police Station, to ensure that the private respondent, namely the 9th respondent, removes the tarpaulin shed within a week from the date of receipt of the server copy of this order. With the above observation.
But if the cattle still subsist, because as per report there is no loss of kindly
tarpaulin sheet is still subsists.
And my lord, on the basis of the complaint lodge, because time to time they have to raise the complaint. But other
kindly take out one submission of mine. It is the habitual act of the private respondent to timely remove the cattle and again.
Then my lord,
when I lost complaint, they made inspection.
Unless a complaint is lodged, otherwise how the police authority or other authority can ensure.
The 9th respondent does not once again put up the cattle shed.
I'm look.
Next.
Serial number 8.
Affidavit of service file.
Yes, on the last day.
Get full lordship. Get.
Next, in this matter, kindly remember, the lordship was pleased to direct the Advocate General to personally mention the matter before the single bench. Today the matter was hard. The learned single judge has been pleased to fix the matter 10th of February. Okay. We will adjourn the matter. Any day after 10th of February. The learned advocate appearing for the state submitted that the matter was moved before the Honorable Single Bench today and the matter has been fixed on 10th February. My lord, one thing, my lord, your lordship has been pleased to grant the interim order till the end of January, my lord. Kindly extend that after that, any day after that, my lord, after 10th of February, my lord. Interim order is still there till the end of January. The interim order, since the learned single bench has fixed the matter on 10th February 2025, the interim order granted on 6th January 2025 stands extended till 28th February 2025. Great. This the matter on 17th February 2025. Grateful, my lord. Next.
Serial number 9.
My application, my lord.
For the respondent Pradhan.
I mean, last occasion,
I have filed two reports, lordship, last occasion.
last occasion, my lord's pleasure was that to file exception against the, my lord, complaint made by the Panchayat Pradhan, my lord. This is exception, my lord.
What was your writ petition?
Copy.
My lord,
I am serving a copy to the, my lord.
the petition, my lord, it was his claim that the Pradhan asked for execution of agreement prior to issuance of, my lord, work order. He is aggrieved by that. The tender notice starts at page 49.
My lord, that is not that, my lord. May I submit, my lord?
Page 51.
What happened, my lord?
clause
I am the lowest, my lord. I am the lowest bidder of the, my lord, tender process. My lord, I was asked to remain present before the Panchayat office for execution of an agreement. I went to the office, my lord, but my prayer is, my lord, some hooligans, my lord, restrained me from entering the premises of the, my lord, Panchayat office. My lord, I have made complaint to the block development officer, local police authorities. Even I have made a prayer to the, my lord, Panchayat Pradhan to allow me to execute the same before the, even if it permit, my lord, to the office of the block development office, my lord. They have, my lord, not allowed, and against that I filed a writ application. Writ petition was dismissed, and against that I have filed a paper appeal before your lordship, my lord. Now, my lord, on last occasion, the Honorable Justice, my lord, Division Bench presided tender, my lord, pleased to pass an order directing them to file a report to that effect, my lord. BDO filed a concerned BDO filed a report, my lord. But that he is not authority to allow any contractor to execute any agreement in his office, my lord. That report is, my lord, possibly in the file, my lord. My lord, therefore, my lord's pleasure was that they to file, ask the Panchayat responding authorities to file the complaint. Now, my lord, what happened, my lord? The Panchayat Pradhan, my lord, filed a complaint against me, alleging therein, my lord, that I have outraged the modesty of the Panchayat Pradhan, my lord. My lord, kindly, is it, my lord, believable, my lord? My lord, kindly see, my lord. I am a contractor. I went to the office, my lord, for execution of agreement. And but now, my lord, they have, my lord, threatened the hooligans engaged by the Panchayat Pradhan, my lord, others.
But now, all right, now the block development officer has inquired into the complaint and found that your allegation was baseless. Leave that aside. Now, we cannot issue any direction because the tender itself has been cancelled.
My lord, what happened? Cancel, my lord, later on, my lord. But, my lord, that was my challenge, my lord.
Oh, you participate in the fresh tender.
My lord, I was not allowed, my lord.
Fresh tender.
Fresh tender, my lord, that was held subsequently. He didn't participate.
My lord, since I am the lowest bidder in the earlier tender, my lord. Earlier tender was, my lord.
Unless you know the law better,
lordships.
Unless and until the tender is awarded, there is no indefeasible right for the petitioner or the participant.
Well,
it is up to the tender inviting authority, even assuming you are the lowest bidder.
My lord,
it doesn't require that the lowest bidder has to suppose you bid it at such low cost, which you cannot perform the work.
No, my lord, that was not their my lord, argument, my lord. Their argument is, my lord, they have restrained me, my lord. My lord,
We have heard you, sir.
kindly allow me, my lord. They have raised, my lord, kindly see the complaint, my lord.
All
The
right.
Pradhan.
This intra-court appeal is directed against
My
the
lord,
order
this is not the
petition by which the writ petition, by which the appellant sought for accepting his bid pursuant to a tender.
My lord, may I submit, my lord? It is not their case, my lord, that it is not, I am not in a position to complete the tender process. That is why they have cancelled. This is not their case, my lord, at all.
Tender invited by.
Actually, they are not allowing us to, the contractor, my lord, to
the appellant alleges
complete the tender process, my
the
lord.
hooligans prevented the appellant from entering the office of the Gram Panchayat for executing the agreement. On an earlier occasion, this court had directed the block development officer to inquire into the matter, pursuant to which a report has been filed on dated 10th December 2024, from which it is seen that, from which it is, not from which, it is, wherein it is stated that the allegations made by the appellant that he was restrained from entering the office of the Gram Panchayat is baseless. However, it is to be noted that the notice inviting tender was cancelled by the committee on behalf of the Gram Panchayat, and fresh notice inviting tender dated 3/10/2024.
My lord, may I submit, my lord? There is no order, my lord, regarding cancellation of the earlier tender, my lord. There is no order.
Single bench has noted that the petitioner has not challenged the cancellation of the earlier tender. In any event, merely because the petitioner was the lowest tenderer, that would not give any indefeasible right to the appellant petitioner to state that the tender has to be executed in his favor. Thus, we find no grounds to interfere. Sorry, sir.
Serial number 10, Srinagar.
Yes.
I'm for the appellant, my lord.
May I place, my lord, in my own way? Yes, my lord. Appellant is the petroleum company, my lord, and the respondent, writ petitioner, is the dealer, my lord. Was the dealer, lord. Now, the dealership is on the basis of the dealership agreement. They are also required to follow the terms and conditions contained in the dealership agreement as well as the marketing discipline guidelines, my lord. Now, my lord, certain terms and conditions has been violated by the dealer. Inasmuch as on a surprise visit, it was detected that 17,000 liters, more than 17,000 liters of petrol, MS, and 13,000 liters of high-speed diesel. There is a positive stock variation of this quantum of. This is a huge variation in the petroleum products, my lord, for which, my lord, fact-finding notice on the same day was issued, my lord. May I just place the list of dates, my lord? That would
yes, that will be easier. In your writ petition, you have given.
Yes, my lord, this is a short list of dates, my lord. But inspection was conducted firstly on March 2nd, yes, my lord. 20. My lord?
Yes, 2nd March.
Yes, my lord. No variation, positive stock variation was found. Subsequently, on 24th of September 2022, my lord, an inspection was conducted. And a huge that is at page 85, my lord, and a huge stock variation was detected. On the same day, fact-finding notice was issued, my lord. In the fact-finding letter, it was categorically stated this quantum of amount has been in variation. Apart from stock variation, there are certain other irregularities also. That was brought into the notice, and it was asked to clarify why there is certain irregularities, my lord. Now, he replied to the same. That was not satisfactory. And on the same day, that is the date of inspection, samples were collected and sent to the laboratory, and it was found that the samples is not adulterated. The oil is intact. Specifications follow as per the requirement, my lord. Now, in reply to the not show cause notice, fact-finding notice, they contended inter alia, that is in the record, my lord, I'm coming to that, my lord, page by page, my lord, that in absence of canopy, my lord, water may have percolated in the tank, my lord. But that is not a ground in view of the fact, my lord, had it been there, my lord, the laboratory trace report would have been, would reveal that. Now, this was the first with regard to the stock variation of such huge quantum of petroleum products, my lord. Thereafter, there are several irregularities. He, in a cursory manner, replied to the same. Thereafter, a formal show cause notice was issued, my lord. He didn't reply to the same even after the reminder. And thereafter, my lord, he filed a writ petition, that was pending, my lord. Now, during pendency of that writ petition, my lord, prior to that, my lord, notice, show cause notice, as well as the reminder was given. He did not reply to the show cause notice, my lord. Filed a writ petition challenging that the show cause notice is bad, my lord. During pendency of such show cause writ petition, my lord, a hearing was given to him, called for, my lord. He prayed for adjournment, my lord, in a nutshell, I'm placing the facts, my lord. At the time of hearing, my lord, on the date of hearing, he prayed for an adjournment, my lord. However, he himself participated. The learned advocates later praying for an adjournment, even that was there, my lord. He participated in the proceeding, made substantial argument, my lord, on the basis. His contention was that he did not file the reply to the show cause notice in view of the fact that all the points regarding the show cause notice has been taken into the writ petition, my lord. And point by point, my lord, all the reasons have been considered and disposed of. And subsequently, 1 month thereafter, my lord, the letter of termination was issued. My lord, it is not that on the day of hearing, we have terminated the same. 1 month, nearly 1 month thereafter, the writ petition was pending, my lord. Thereafter, the instant writ petition was filed, my lord, challenging the order of termination, my lord. Now, that was decided, holding that the letter of termination is bad and for resumption of the supply, my lord. Now, my point is that although there is a provision of appeal, my lord, these are all the facts which he has raised, my lord, and there is an appellate authority that can be proceeded with. Apart from that, there is an arbitration also, my lord. Now, my lord, may I just one by one, may I place the...
No, before that, yes, you tell us on what ground, broadly on what grounds the writ petition was allowed.
Writ petition was allowed on the ground that a violation of the natural justice, my lord. Since during pendency of the writ petition, we have decided, my lord. My case is this, my lord, on the very day when we asked for hearing, my lord, we did not dispose it off. That was disposed of, or the order of termination was passed 1 month thereafter,
But
my lord.
pursuant to the hearing notice, he participated.
Yes, my lord. He prayed for an adjournment. But he himself, that is in the writ petition also, he himself, whatever he submitted regarding all the points, my lord, that has been recorded in the writ petition as well as the order, my lord. Apart from that, my lord, he didn't reply to the show cause notice, whatever be the reason. First thing, my lord, the most importantly, my lord, in reply to the fact-finding notice, he stated that there was an water. Subsequently, he changed the stand, contending inter alia that a load, the tank load of another retail outlet was decanted. My lord, the date, as your lordship will find from the list of dates, the decanting of that particular product was in 2021. However, 2 successive inspections was on 2nd of March 22. There was no such positive stock variation detected. Had there been any such oil poured in the tank, it would have been revealed in the earlier inspection. That was totally a baseless ground, my lord. Thereafter, first, due to non-availability of the canopy, thereafter, load was transferred from another retail outlet. That was during 21, my lord. My case is of 22, my lord. So had it been there, there would have been detected in the earlier inspection also, my lord. That was not detected. Thereafter, he contended inter alia that there was some short delivery or the can measurement. That was a shortfall for which this positive stock variation occurred, my lord. But in any event, that particular defect cannot cure the huge quantum of 17,000 liters, my lord. This is first, my lord, natural justice. Secondly, the punishment of capital punishment, that is the nature of termination of dealership, is disproportionate to the, but my lord, so far as critical irregularity is concerned, this particular positive stock variation in the marketing discipline guidelines, which is relied upon by the parties, my lord, he is bound to follow that particular procedure, which states that positive stock variation without any reasoning, that is to be unauthorized purchase, which is unauthorized purchase, termination. Now, his ground is this.
On whom is the burden of proof?
No, that has not been provided in the guidelines. Well, may I? But he is the custodian of the oils. So at least some clarification, some plausible clarification ought to have come from him. Unless that is done, how can we know? But what will be the ground? He is the custodian and he cannot be allowed to carry on his business by purchasing and selling this product, my lord. In absence of any ground, what is the reason for this particular positive stock variation of huge quantum? The reasonable conclusion is there was a purchase from where he can get. Now, the second.
No, the learned single bench says the burden is on you.
Yes,
that is the procedure.
Now, purchase, unauthorized purchase.
Then, if you are governed by the discipline, marketing discipline guidelines, see, this is a controlled commodity. If the stock variation is huge, if it is like 100 liters, 150 liters, you can give some, vaporization, etc. There are a lot of such decisions have come. But you cannot purchase this,
Unauthorized purchased, according to.
Yes, you cannot purchase these petroleum products from the market.
Right, madam.
So therefore, if you give a plausible explanation.
Possible expression in their fact-finding letter, they have said that the seal of the tank is intact.
Yes.
That is they have said so. In
Seal of the tank is intact. The quality of the product is also.
Then there cannot be, I cannot purchase from the outside and pour in the tank.
So therefore it is.
Yes, I give the explanation. There is explanation in that. And they have given without any hearing initially. That's why the interim order passed in the writ petition by this honorable court. Why the interim order was passed? Staying the termination. Thereafter, final hearing, termination order was set aside.
And now you are continuing your.
No, I have not been continued. I have not been allowed to continue.
No, my lord. There was no interim order. We gave the hearing at that relevant point of time. When interim orders there for what? Before termination.
After termination.
After termination, not to give effect to the termination. That order was there. During pendency of the interim order, we didn't terminate.
That is stated. Why
No.
interim order was passed?
You prayed for that, but there was no such interim order restraining us from giving a hearing or terminating.
Staying the termination.
The order of termination. There was initially an order.
Why?
Thereafter, it was heard and disposed of.
No, if there is a stay of termination,
yes, madam.
It cannot automatically mean
Got
to.
back my position. That's true, my lord. But why the
Unless there
termination
was
was stayed?
specific direction that continues supply.
But that was why the stay of termination. Without granting any hearing, I prayed for I will express before your lordship my letter to that effect that these 3 days are holidays before this honorable court. You can kindly adjourn the date of hearing and matter has been fixed at item number 5. That was my letter. I will show to your lordship.
But we didn't dispose it off on the same day.
That is true, sir. But you could have given him a short adjournment.
But your lordship will find
you suspended the operations immediately.
Yes, my lord. And in his initial writ petition, he contended to resumption of supply. This is the second set of writ petition.
That he withdrew.
But my lord, that can be done, my lord. He can prefer an appeal since a disputed question of fact is involved in this matter.
If you see the final order, page 115.
45 of the stay application.
No, 115.
150 of
order of termination. The lordship is looking at the order of termination. Just a second. Yes, 150. On the basis of that hearing only.
150 of what?
150 of
15.
It's termination.
kindly come to page 111 once. What is my letter addressing to adjourn the date of hearing? 111. That is written by me. What is my letter?
And that has been considered, my lord.
No, you could have adjourned the matters. You
No, my lord,
see,
the petitioner,
no, no, you please see page 160.
116.
Where have you recorded that he sought for an adjournment? Adjournment is refused. And when was the deal? When was the dealership granted to you?
Dealership was granted 2015.
15. Earlier there is no.
No such allegation. No such allegation. I will show why this positive stock variation. I will show to your lordship. From their document on, not from my document. They are saying there is a while I am
But because your reply to the show cause notice was not on record.
No, well, I was
Your
challenging.
oral submissions also was not on record. So therefore, how do we test the correctness of this?
I will show when there is a positive stock variation. It is burden of proof on the oil company to establish there is a path. I have purchased the same from the outside. Until and unless they establish the same, there cannot be a punishment of termination. I will show from the brochure.
But
All right, we'll continue.
Yes.
না এটা তোকে দিলাম তো
নিচে এইটাই।
তাহলে নে।
This is the group 8 matter.
Yes, my lord.
No,
Group 9.
Residual. Group 9, petrol pump. It's a residual petrol pump.
Petrol pump.
Not under essential
No,
commodity.
not under Group 9.
Continuing matter, item number 10.
Your Lordship may kindly come to the order of termination, my lord. That starts. Letter praying for an adjournment is at 111, my lord.
Yes.
Now, so far as the positive stock variation, my lord, the person concerned contention has been clearly dealt with at page 117, my lord.
Oh, the 112 is the minutes.
Yes, sir. Yes, my lord, this starts from minutes has been recorded there.
So the dealer appeared.
Yes, my lord. And as a matter of fact, if your lordship turns to the writ petition, my lord, that is also an annexure, my lord, that that starts from page 33 of the stay application, my lord, that all the points have been taken by the writ petitioner before the hearing authority, my lord. That is, starts from 26 has been categorically specified. Whatever defense or whatever submission he is having in his writ petition has been placed by the writ petitioner himself before the hearing authority, my lord. Now, may I place paragraph 26, my lord, of the writ petition at page 33. Your petitioner states that during the course of hearing, your petitioner categorically submitted that learned advocate of your petitioner has already informed the filing of the writ petition and also requested for adjournment of the hearing. And since all points of defense in response to the show cause notice is covered in the writ petition filed by your petitioner did not file the reply to the subsequent show cause. Now, my lord, kindly sees the next page, my lord. It is their writ petition. During the course of hearing, your petitioner categorically submitted that alleged positive stock variation is on account of unloading of load allocated to your petitioner's another retail outlet, namely Shoptika Filling Station on 31/2021. My lord, this 2021 is prior to the inspection, my lord. There were two inspections, as I indicated in my list of dates, my lord. First inspection was on 2nd of March 2022. No positive stock variation was detected. Had it been transferred, unloaded on during 2021, my lord, the inspection would have reflected that during 2022.
So this variation was found pursuant to the 24th September.
Yes, my lord, 24th of September. The earlier inspection was on 2nd of March, my lord. No positive stock variation was detected. Now, his contention is this, that the Shoptika Filling Station's load was unloaded on 30th of January 2021, my lord. Had it been unloaded on that day, my lord, the positive stock variation would have been detected on the first inspection, that is 2nd of March 2022 itself. As a matter of fact, these particular findings that there was no stock variation has not been challenged, that the findings were erroneous, that was also not under challenge, my lord. Now, your lordship kindly takes the next point, my lord, the same paragraph, During the course of hearing, your petitioner categorically submitted that the several complaints were lodged by your petitioner with regard to the nozzle lock, and the service engineer, under the instruction of the IOCL authority, attended the petitioner's retail outlet, and after such problem, your petitioner doing delivery check by 5 liters measuring can, and the same was recorded in the DSR and poured back to the tank. Thereafter, during course of hearing, your petitioner categorically submitted that at no point of time your petitioner sold petroleum product manually. All the tank, it was sold through automation system. During the course of hearing, your petitioner also categorically submitted that the petitioner never found any short delivery of the petroleum product from his retail outlet while measuring those products by the 5 liters measuring can maintained by your petitioner on the basis of the calibration certificate issued by the appropriate authority. However, on the date of inspection, short delivery was observed by the inquiring personnel while measuring the product by a 5 liters calibrated measuring can belongs to the IOCL authority. This is also a reason for positive stock variation, my lord. Now, my lord, all these points is the subject matter of the writ petition itself. On this ground, he has filed the writ petition, my lord. And now all these points were taken in the hearing in his own volition, my lord. That is also specified in my affidavit in opposition. We didn't force him. He placed the letter, my lord, but he submitted. He was present, he made submission. It is not that his contention was not recorded or his contention was not there. This is the first thing, my lord. Second thing, my lord, absolutely the marketing discipline guidelines provides that unauthorized purchase should be established, my lord. But, my lord, so far as the existence of the product is concerned, the excess product to the extent of 17,000 in HSD and 13,000 in MS and 13 HSD, my lord, there has to be some reason, some basis. He cannot shrug off his responsibility by saying that they failed to establish that I have purchased the same. So I will be, he can go scot-free, my lord. That cannot be, my lord. There must be some reason for such deviation. Now, your lordship kindly sees that now page 68, my lord, this is dealership agreement, clause 30. Page 68, running page 68, my lord, this dealership agreement. The dealer shall not purchase, obtain, or otherwise acquire possession from any person, firm, or company other than the corporation any product used, stocked, or sold by the dealer or in connection with the dealer's business in the products hereunder without the previous consent in writing of the corporations, which the consent the petitioner may refuse, vary, and withdraw at any time or from time to time in the entire discretion, my lord. Now, my lord, kindly sees that the product was detected in his tank, my lord. He is the custodian of that particular tank along with the products, my lord. Now, he has to substantiate where from he received such products, my lord. Now, stock variation of MS and HSD in terms of marketing discipline guidelines has been specified in page 177, running page 177, my lord.
Yes.
Now, page 78 provides 178, my lord. In case of positive stock variation, my lord. Page 178. In case of positive stock variation beyond permissible limits, samples will be drawn and sent to laboratory for testing. Sales and supplies of all products to be suspended immediately. Study to be carried out to identify the reasons for stock variation. If the sample passes, but some other irregularity like unauthorized purchase, etc. is established, action to be taken accordingly. However, if the sample fails, action in line with that of the adulteration will be initiated. Now, in our case, my lord, that sample passed, but there was positive stock variation, my lord. No explanation, plausible explanation was received, my lord. He went on shifting his stand. First, non-availability of the canopy. Thereafter, unloading of another retail outlet's load, which is cannot be the reason, my lord. In any event, he failed to justify the reason for such stock variation, my lord. It is absolutely correct that the finding was that the seal of the tank was intact, my lord, but that is there. But he has to justify the reasons for some stock variation, my lord. The normal conclusion is that he must have procured the same from any other source, my lord. Unless that is there, the tank cannot have huge quantum of such petroleum products, my lord. There was no adulteration, as also there was no rainwater inside the tank. He is liable to explain the reasons for the same, my lord. Now, your lordship kindly comes to the penalty that is at page 187, my lord. That's critical irregularities, my lord, on the basis of which the dealership was terminated, my lord. This is clause 8.2, critical irregularities. Clause 6 provides unauthorized purchase, sales of products. And clause 5, unauthorized storage facilities. Now it provides action, termination at the first instance will be imposed for the above irregularities. So if there is a positive stock variation in terms of clause 5.1.6, my lord, that has been specified, unauthorized purchase, 5.1.6, just I indicated, my lord. Now, your lordship again comes to the order of termination. That is at page 117, my lord.
117.
Yes. May I please? It's his contention. After hearing him, the petitioner, it has been recorded. You claim that stock variation is on account of unloading of the load allocated to Messrs. Shoptika filling station on 31/2021, having product of 4 kiloliter MS and 8 kiloliter HSD. You have also claimed that you have done this on verbal advice of the then IOCL officials of Durgapur DO, and this volume was not recorded in DSR. Reasons for not accepting the claim. Your submission confirms that you have committed gross violation of management marketing discipline guideline and dealership agreement. Further, it is pertinent to mention that positive stock variation of 17 kiloliter in MS and 13 kiloliter in HSD is observed, and it is claimed by you that tank TT unloaded product of 4 kiloliter MS and 8 kiloliter HSD at your RO, leaving variation of 13 kiloliter MS and 5 kiloliter HSD as unaccounted. Though you admitted that during the personal hearing that 4 kiloliter MS and 8 kiloliter HSD was unloaded at RO, however, you have failed to explain the variation of 13 kiloliter MS and 5 kiloliter HSD. As such, it is construed that unauthorized purchase is the only logical conclusion of such high positive stock variation beyond permissible limits. Thereafter, your claim, there were repeated delivery problem due to nozzle check and several complaints were lodged, which were attended by the service engineer under instructions from IOCL sales officer. You informed that after every such problem, you were performing delivery check by a 15-liter can. The same quantity was recorded in the DSR and was poured back to the tank. Reasons for not accepting the claim. The complaints lodged in the portal were analyzed. Total of 19 complaints were observed during the period of 31/2021 to 24/9/22, 20 months. And they are regular R&M issues. Further, most of the complaints were closed within 2-3 days of generation of complaints. Also, testing recorded in DSR was accounted during stock reconciliation by the MDT. Thus, your contention is not acceptable. Now, at any point of time, product was not sold in manual mode and it was always sold through automation system. Reasons for not accepting the claim: automation data was analyzed and stock variation was found to be matching with the quantity as compared to physical reconciliation as per meter reading and dip during the inspection. Now, lastly, last at page 120, my lord, this is the concluding portion of the
Yes.
Now, the conclusion is at page 120, my lord, that in view of the foregoing, your RO dealership under the name and style of Messrs. Kirith Filling Station is hereby terminated with immediate effect for violation of clause such and such, which are classified as critical irregularity under clause 8.2, and as well as violation of clauses such and such of the dealership agreement dated such, and as such, you cease to be our retail outlet dealer. Since the termination is on account of MDG irregularity, security deposit is hereby forfeited as per dealership selection guidelines. In line with clause 52 of the agreement, our field officer will be visiting such and such for removal of goods and properties belonging to the corporation. The petroleum product that may be available at the RO shall be dealt with in accordance with the policy of the corporation and the rules governing. You may please note that in case of termination arising out of invocation of MDG, the dealer will have the right to appeal within a period of 30 days from the date of receipt of order before the appellate authority through concerned divisional territory regional office of the oil marketing company. The appellate authority is empowered to decide the matter and appeal will be disposed of preferably within 90 days from the date of filing of the appeal in the division. This letter has been issued without prejudice. my lord. This appeal has not been preferred, my lord. Now, so far as the contention of the writ petitioner, some material facts, disputed matter of facts has been raised, my lord. So far as the seal has not been broken intact and 5 milliliter ml on every occasion has been repoured into the tank, and for this reason, there was such positive stock variation, my lord. The calculation has been made but has not been relied upon by any of the parties, since question does not arise, my lord, that such calculation, whether such minimum 5 milliliter in successive occasions can compensate or can cause deviation of 17,000 liters, my lord. That was not there, my lord. Now, my lord, the learned single judge, my lord, in the last may I please the order of the single judge, my lord? Not.
You show from the operative portion.
Yes, my lord. Now, my lord, may I place from page 253, my lord?
Yes.
The last paragraph, from the last paragraph, my lord. Yes, the order of termination was sought to be justified. This is as page 253, my lord. Justified by Mr. Chakraborty on merit as well, contending that petitioner did not deny that there was no positive stock variation, and the petitioner took 3 stands in 3 different times. Initially, the petitioner took the plea that since there was no canopy over the outlet, there might be variation of stock in the monsoon time, and then in show cause notice, he took the stand that due to the problems in nozzle locks, there were shortage of delivery, and in the writ petition, he took the plea that load of Shoptika filling station was poured in the tank of the subject outlet. Submit that in almost in every case, difference between SAP receipt and receipt as per automation system occurs, and he vehemently, strenuously contends that for the reasons assigned by the petitioner, there cannot be positive stock variation. He vehemently contends that the respondents have rightly passed the order of termination of the petitioner's retail outlet. Now, it is condign to note that non-entertainment of petition under jurisdiction of the High Court when an efficacious alternative remedy is available is a rule of self-imposed limitation and or restriction. It is essentially a rule of policy, convenience, and discretion rather than a rule of law. It is a rule of discretion and not a rule of jurisdiction. There cannot be a blanket ban. Whether or not the extraordinary jurisdiction would be invoked is to be decided in the context of the facts and circumstances of the case at hand. In this perspective, the reference of Whirlpool Corporation versus Resettlement would be instructive, wherein it was held that despite existence of efficacious alternative remedy, a writ petition can be entertained if the same is filed for enforcement of any of the fundamental rights, or where there has been violation of the principles of natural justice, or where the order or proceedings are wholly without jurisdiction, or where virus of an act is challenged. It is apposite to refer an authoritative pronouncement made in the case of Union of India versus R. Redappa, reported in 1993 for SEC 269, wherein it was ruled that once the High Court is satisfied of injustice and or arbitrariness, then the restriction, whether self-imposed or statutory, goes removed, and no rule or technicality on exercise of power can come in the way of rendering justice. Whenever a plea of breach of natural justice is made against the state, and if such plea is found sustainable, the same can be treated as arbitrary action of the state, which attracts the provision of Article 14 of the Constitution of India. It is axiomatic that the principle of natural justice are very flexible principles, and the same cannot be applied in any straitjacket formula. The theory of reasonable opportunity and the principles of natural justice have been evolving, and with the development of law, the element of de facto prejudice is treated as a factor to be considered. In the judgment of State of UP versus Sudhir Kumar Singh, it was held that where procedural and or substantive provisions of law embody the principles of natural justice, their infraction per se does not lead to invalidity of the orders passed. Litigant is to show that prejudice has been caused to him following non-observation of the principles of natural justice. In the case at hand, the petitioner assailed the show cause notice in a writ petition, and hence he did not respond to the show cause notice. Now, pausing here for a moment, my lord, the show cause notice was issued during November. Reminder was also there in November. Subsequently, after nearly 1 month thereafter, he filed the writ petition, my lord. During pendency of the writ petition, the respondents took the matter for hearing, rendering the writ petition infructuous, my lord. Basing upon a statement made in the writ petition to the effect that all points of the defense in response to the show cause is covered in the writ petition, the respondents have proceeded. Thereafter, contains that the petitioner could not justify the reason behind positive stock variation. So even if the petitioner would have been given opportunity to submit reply to show cause notice, the same would not make any difference. In such fashion, despite having knowledge of pendency of the writ petition, hearing has been taken, rendering the writ petition infructuous. A coordinate bench of this court has been forced to comment that the respondents have acted in unwarranted haste. Now, my lord, the order was not passed on the same date of hearing, my lord, 1 month thereafter, nearly. It would not be always proper to allow the state and its functionaries to dispense with the requirement of the principles of natural justice on the plea that no prejudice would be caused, or on the plea that even if such principles would have been followed, the same would not make any difference. Those pleas also have to be considered in the context of facts and circumstances of the case. The basic concept and or theory of fair play in action is squarely applicable in administrative, judicial, and quasi-judicial field. When an authority assumes jurisdiction to discharge quasi-judicial function, then such authority must act fairly and impartially. In case of disciplinary proceeding and in case of proceeding of like nature, when one official of a department is the complainant and another official of that department is quasi-judicial authority to test the veracity of such complaint and to punish, then it is essential that such authority, while discharging quasi-judicial functions, must act impartially and without any bias or predetermined mind. The settled proposition of law is that if the court finds that authority has acted arbitrarily and with closed mind, the court can extend the compass of judicial review to render justice. Rule of law cannot afford to tolerate arbitrariness and unreasonableness. Thereafter, scope of judicial review grounded on illegality, irrationality, say, Wednesbury's unreasonableness and procedural impropriety. The doctrine of reasonableness gives way to doctrine of proportionality also. Judicial review of administration action is intended to prevent arbitrariness, irrationality, unreasonableness, bias, and malafidus. The basic requirement of Article 14 is fairness in action by the state. State must act for a discernible reason and not whimsically, and also not for any ulterior purpose. Admittedly, the scope of judicial review must be confined to decision-making process, but if it is found that decision is perverse, irrational, or grossly disproportionate, that decision will come under the purview of judicial review. In the case at hand, the show cause notice dated 25/11/22 regarding positive stock variation, the following observation was made. Accordingly, study was carried out, and it has been observed that positive stock variation is attributable to unauthorized purchase of products as per clause 5.1.6 of the amended MDG 2012, which stipulates as under. In page 5 of the show cause notice dated 25/11/22, the following comment was made. Positive stock variation beyond permissible limit is a violation of clause 5.1.11 and clause 5.1.6 of management discipline guideline Marketing Discipline Guideline 2012 as detailed in point 1 above. The same is critical irregularity in line with clause 8.26 of MDG 2012, which attracts termination at the first instance. Moreover, aforesaid acts of omissions on your part also tantamount to violation of clause 3, 29, 30, 34, 39A and 42 of the dealership agreement dated 31/12/2015, executed by you. In the letter dated 13/1/23, which was issued to give reminder to the petitioner to submit show cause, the authority concerned opined as follows. Accordingly, a show cause notice reference number such and such was issued to you for violation of clause 5.1.11 and clause 5.1.6 of MDG of 2012, which is critical irregularity and attracts termination of first instance in line with clause 8.24 of MDG of 2012. Moreover, aforesaid acts omissions on your part also tantamount to violation of clause such and such of the dealership agreement dated 31/12/15, executed by you. In case of Oryx Fisheries Private Limited versus Union of India, reported in 2010-13 SCC 427, the judgment was referred as such of 2004. MS Bimola Gas Service and others versus Indian Oil Corporation and others. It was observed that it is well settled that a quasi-judicial authority, while acting in exercise of its statutory power, must act fairly and must act with an open mind while initiating a show cause proceeding. A show cause proceeding is meant to give the person proceeded against a reasonable opportunity of making his objection against the proposed charges indicated in the notice. In the judgment of Oryx Fisheries Private Limited, it was held that at that stage, the authority issuing the charge sheet cannot, instead of telling him the charges, confront him with definite conclusion of his alleged guilt. If that is done, as has been done in the instant case, the entire proceeding initiated by the show cause notice gets vitiated by unfairness and bias, and the subsequent proceeding becomes an idle ceremony. On reading of the show cause notice, the person against whom it has been issued must have confidence that if he can show acceptable and or satisfactory cause, he can prove his innocence. But if he finds that the submission of show cause would be mere empty formality, as the authority has already made up its mind, then basing upon such cause notice, a fair proceeding cannot be conducted. In the show cause notice itself, the authority concerned observed that positive stock variation was attributable to unauthorized purchase of the products as per clause 5.1.6 of MDG, and positive stock variation being violation of clauses 5.1.11 and 5.16 of MDG is a critical irregularity which attracts termination at the first instance, and the acts and omissions on the part of the petitioner tantamount to violation of clause 329 such and such. Hence, it is clear as day that the authority, even at the show cause stage, has confronted the petitioner with definite conclusions of this alleged guilt. My lord, pausing here for a moment, my lord, this show cause notice, the second show cause notice. First, there was a fact finding. He failed to justify, my lord. And thereafter, this show cause notice was issued on the backdrop of such finding. And after making the study and receiving the sample report from the laboratory, my lord. Kindly see the list of dates, my lord. That initial fact-finding letter was issued on 24th September itself, my lord. And the reply was received on 1st of October 2022. Laboratory test on 8th of October, and committee was formed on 10th of October. And thereafter, committee submitted on 26th October, committee submitted its reports. And thereafter, approval for issuance of show cause notice was received, and thereafter show cause was issued, my lord. All these stages, and not by an individual person, my lord, from the sales officer up to the DGM level, till up to DGM level, my lord. File notes are passed and their views were taken. Now, my lord, hence it is clear as day that the authority, even at the show cause stage, has confronted the petitioner with definite conclusions of his alleged guilt. Basing upon the ratiocination of the judgment of Oryx Fisheries Private Limited, there cannot be any qualm in the mind of any prudent man to perceive that the authority concerned has proceeded with a preconceived mind which is sufficient enough to vitiate all the proceedings initiated and the actions taken basing upon such show cause notice. Making an endeavor to defend the decision of the authority concerned on merit such and such has invited the observations of the court on the defensibility of the decision of the authority terminating the petitioner's retail outlet. Generally, the word guidelines, this is important, my lord. Generally, the word guidelines means an agency, statement, or declaration of policy that the agency intends to follow, that does not have any force or effect of law, and that binds the agency but does not bind any other person. Undoubtedly, no circular, notification, or rule or act has been placed before me to show as to how such guidelines can have statutory force. My lord, but this guideline binds the parties, my lord. They have to follow these particular guidelines. Your lordship rightly indicated is the control goods. They have to follow certain procedures, my lord. Yet, having scanned the anatomy of the guidelines, it is luminescent that Chapter 8 deals with the actions to be taken by the OMC under MDG, and Clause 8.1 MDG speaks that all irregularities are classified into 3 categories: critical, major, and minor. Clause 8.3 contains enumeration of major irregularities, and Clause 8.34 speaks about stock variation beyond permissible limits but sample passing quality test. Whereas Clause 8.2 has categorized critical irregularities, and Clause 8.26 speaks about unauthorized purchase, sales of products. Clause 8.2, which speaks about critical irregularities which entail termination at the first instance, whereas Clause 8.34 prescribes punishment, suspension of sales and supplies for 15 days at first instance, suspension of sales and supplies for 30 days at second instance, and termination of the dealership at the third instance. The relevant portion of Clause 5.1, 5.1.6 and MDG are set out below. I need not travel into that. Now, your lordship kindly may come to page 262. Thereafter, it starts after quoting this portion of the MDG. Page 262, in the letter styled as fact-finding letter dated 24/8/22, well, at page 262. In the letter styled as fact-finding letter dated 24/8/22, whereby explanation from the petitioner was sought for in respect of irregularities referred to in serial number 1.2 and 3 in the table inserted therein. Clause 5.1.11 was invoked, most probably for the reason that the test report of the samples was not received then. Suffice it observed, no adulteration was found in the test. In the show cause dated 25/11/22, the authority concerned already decided that positive stock variation was attributable to unauthorized purchase and invoked 5.1.16 of amended MDG. So it is graphically clear that at the show cause stage, the respondents decided to invoke Clause 5.1.6 and 8.26. Clause 5.1.11 directs that if case of positive stock variation beyond permissible limits, samples will be drawn and sent to laboratory, and if the sample passes but some other irregularity like unauthorized purchase, etc., is established, action to be taken accordingly. Whereas Clause 5.1.6 says that purchase of the products from sources other than those authorized by the oil company would be treated as unauthorized purchase, and any sales of MS/HSD other than through the dispensing units of that RO would be treated as unauthorized sales. Hence, two things say: purchase of products from other source and sales of MS/HSD other than through the dispensing units are to be proved before holding that there was unauthorized purchase. There is no guideline when and how unauthorized purchase would be held to have been established, and burden rests upon whom. Is it the burden upon the authority concerned who alleged unauthorized purchase to prove, or there is reverse onus? The authority concerned has come up with positive assertion that hence ordinarily burden rests with it. If a dealer is asked to discharge his burden to prove there was no unauthorized purchase, then burden to prove negative fact would be imposed upon him. In that case, only a special legislation or provision can come in the rescue of the authority to impose reverse onus upon the dealer. MDG itself did not give unfettered power to invoke clause 5.1.6 unless unauthorized purchase is proved. There cannot be any automatic conclusion that since there was a positive stock variation, there was unauthorized purchase. Now, my lord, pausing here for a moment, my lord, but at least there should be some justification for having such huge quantum of unauthorized, not unauthorized, unauthorized, I don't know, but petroleum product in his tank. So it is quite vivid that for the same offense, namely positive stock variation, both clause 5.1.11 and clause 5.1.6 can be invoked. An action under clause such and such can be taken in absence of the guideline when clause 5.1.11 would be invoked, and dealer shall be punished under clause 8.34. And when 5.1.6 would be applied and dealer would be punished under clause 8.26 will lead to arbitrary and or whimsical action from the end of the officials handling the dealership products of IOCL. If they remain pleased with dealer A, they may invoke 5.1.11, and the other case they may invoke clause 5.1.6. Now, it's important. Termination of dealership can be stated to be capital punishment in like proceeding. Before imposition of capital punishment, even the court is to assign reason, and the court is to consider aggravating and mitigating factors and follow the well-accepted theory or theories of punishment. And if the court takes resort to retributive theory instead of the reformative theory, it has to give special reason for that. My lord, this particular observation does not apply, my lord. MDG specifically provides that in the event unauthorized purchase is established or there is unauthorized purchase, it is a critical irregularity. Even in the first instance, it can be terminated. Here, no special reason has been shown as to why the authority is not invoking clause 5.1.11 and clause 8.34, and why they are invoking clause 5.1.6 and clause 8.2.6 of MDG. The authority concerned has abruptly jumped to the conclusion in a closed mind. My lord, here pausing for a moment, it's not that in a closed mind, there must be some justification. It may be a small quantum of oil, my lord. It's not that 17,000 liters in particular HMS and 13,000 in HSD, my lord. That was detected, and it is a continuous process, and it occurred in just a span of 6 months. Since earlier inspection was on February and this was in September. So within a span of 6 months, this particular variation was detected, my lord. Positive stock variation in the petitioner's retail outlet has been detected for the first time, and hence applying the doctrine of proportionality, it can be argued that the punishment is disproportionate, my lord. But this does not find in MDG. Even it is the first time, if it is established there was an unauthorized purchase, termination is the only conclusion, my lord. Now, there must be some justification. What would be the conclusion of the oil company? If there is no ground where from he received such product, the only conclusion he has to satisfy, the whatever reason he has stated has to be justified. There must be some reason or basis of such observations. Whatever ground he has stated, he cannot shrug off his responsibility in that manner that you couldn't prove, so I am not within the zone of termination, just suspension of 3 months. A decision is an authority for what it decides and not can logically be deduced therefrom. Even in the slight distinction on fact or an additional fact may make a lot of difference in decision-making process. The judgment is a precedent for the issue of law that is raised and decided, and not the observation made in the facts of any particular case. In case of Indian Oil Corporation Limited versus Taposh Kumar Das, the order by which an arbitral award was set aside was assailed. The dealer invoked arbitration clause at show cause stage, and subsequently order of termination was passed, and hence permission was accorded to initiate a fresh reference. There is no scintilla of doubt regarding binding effect of the ratiocination enunciated in the judgment of State of UP versus Sudhir Kumar Singh, but the same is distinguishable in the facts. In view of the foregoing analysis, it can safely be concluded that in preconceived mind, even at the show cause, the authority concerned decided to invoke clause 5.1.6 and 8.26 of MDG and confronted the dealer with definite conclusions of his alleged guilt, and hence all the subsequent actions taken on the basis of such show cause notice stand vitiated. Regarding the merits of the decision, it can be said that the authority has proceeded in unwarranted haste, and though no plausible materials have come, yet abruptly jumped to the conclusion that there was unauthorized purchase without assigning any reason and placing a reverse onus upon the petitioner. The person or authority having power to punish must keep in mind that by awarding punishment, fundamental or other rights of the wrongdoer are snatched away, and hence punishment must be commensurate, proportionate, and are justified. And before applying deterrent theory of punishment and before awarding highest punishment, such person or authority must be satisfied that the wrongdoer is incorrigible and beyond the reach of reformative influence, and such person or authority must assign reason for awarding highest punishment. The positive stock variation was detected in the petitioner's retail outlet for the first time, and in this perspective, it may be argued that the punishment is not proportionate and the same has been awarded without assigning any special reason. Accordingly, for the above reasons, the decision to terminate the petitioner's retail outlet dealership cannot be sustained. Consequently, the writ petition is allowed. The show cause notice dated 25/11/22 and the order of termination dated such are set aside. The respondents are directed to resume supply of MS and HHD and other products, if any, at the petitioner's retail outlet, namely Krit Filling Station, within 4 weeks from the date. With this observation, the order of the writ petition stands disposed of, my lord. Now, so far as positive stock variation, nothing has been detected. What would be the fate of those particular products? 17,000 liters of MS and 13,000 of HS. My lord, the judgment that was relied upon may I hand over 2 copies, my lord? This was not dealt with in the by the trial court, my lord. ওই তো এটা কৃষ্ণমুরারির জাজমেন্টটা দিয়েছিলাম একটা কপি তোকে, আছে তোর কাছে? তাহলে দিচ্ছি, দাঁড়া। পুরোনো পুরোনো তোর কাছে আছে, আগের থেকে গেছে দেখ। Now, my lord, from third paragraph, Parsri such and such learned counsel for the respondents raised a preliminary objection that as per clause 8.9 of marketing discipline guidelines, the petitioner has a remedy of appeal, and hence the petition is liable to be thrown out on the ground of existence of alternative remedy. Clause 8.9 such and such has been quoted, my lord. Thereafter, the learned counsel of the petitioner submits that existence of alternative remedy is not a complete bar on the power of the court to entertain the writ petition, and thus the writ petition is not liable to be dismissed on the ground of existence of alternative remedy. There cannot be any dispute with the proposition that existence of an alternative remedy does not operate as a complete bar on the power of the court to entertain the proceedings. It is well settled that when there is an adequate alternative remedy, normally the court should not interfere under Article 226 on account of the self-imposed restriction as the rule of discretion and expediency, and not one of the jurisdiction or limitation on the power of the court. The reason being that a remedy by way of a writ is an extraordinary remedy. It is well settled principle that high prerogative writ should ordinarily not be issued where an alternative remedy equally efficient and adequate exists. Normally, when an adequate alternative remedy under the statute is available, the high courts do not enter into the disputed questions of fact, the resolution whereof requires going into the evidence of which sufficient material may not be available on the record of the writ petition. In the case in hand, disputed questions requiring to go into evidence in respect of the dispute is required, and the petitioner has an efficacious alternative remedy under the provisions of MDG, and thus this writ petition is not liable to be entertained on this ground. At this stage, learned counsel for the petitioner submits that since the Provisions of clause 8.9 provide that during the period of appeal, in case the supplies were not suspended earlier, the retail outlet will be kept open. As such, before he files an appeal, the supply to the retail outlet which has been stopped after passing of the impugned order ought to be resumed and necessary direction in this regard be issued. The argument is misconceived. Clause 8.9 of the MDG provides remedy of appeal to be filed by the dealer within 30 days from the receipt of the order, and appellate authority has to dispose of the appeal as far as possible within 90 days from the date of filing of the same. And thus, during this period, in case the supplies were not suspended earlier, the retail outlet shall be kept open. The petitioner cannot get direction as prayed for without even filing the appeal. The provision of keeping the RO open is for the period during which the appeal has been filed and is pending adjudication. In such view of the matter, no such direction as prayed for is liable to be issued. The petitioner has an efficacious alternative remedy of appeal. The writ petition accordingly stands disposed of. Now, my lord, the basic. Now, my lord, submission is this, my lord, there is an efficacious appeal, not more than 90 days. Your lordship fixes that time period. They may prefer an appeal. All the facts may be placed and may be disposed of. And these are all documents, relevant facts. No further inspection is required also in the outlet. Whatever he has submitted in his writ petition, his grounds, my lord, for such positive stock variation. Apart from that, even thereafter, if he wants to take any subsequent points, let him. That's my submission.
Yes.
My learned senior friend had argued 3 points, most mainly. One, when there is an alternative remedy, either to prefer appeal, whether writ petition is maintainable. Second, burden of proof lies on whom to establish when there is a positive stock variation. And third is that, but opportunity of hearing was given as such there is no violation of principle of natural justice. Now you will also first come to the show cause notice itself. Page 103. First. Prior there to you will also kindly come to page 85. That's a fact finding letter. Page 85. Made these 4 questions. Page 85 is the fact finding letter. It's dated 24th September 2022. Sorry. What is their recording, not mine?
Yes.
I read once. You have been operating as retail outlet at Village and Co. such and such in the name of teeth filling station on the terms and condition in the dealership agreement dated 31st December 2015. MBE 2012 and other relevant rules and regulation Government of India State of West Bengal. A reference is made that the MDT inspection at your retail outlet on 24th September during the inspection from the nozzle dispensing unit were found short. It is not mine. It is not a disputed fact. It's an admitted fact by them. There is a problem with the nozzle. Next. In every measure 5 liter in the first and second and third, the details are given below. You will also kindly come to first. Short by 40 ml, short by 40 ml, short by 40 ml. Every 5 liter. This is not my recording. This is their recording. Status of the seal, intact. All the 3. There is no tampering of the seal. Whether they are saying that I have purchased from the other side, then if I purchase from the other side, I have to pour in the tank. They are saying this status is status of seal intact. They are saying every 5 liter there is a short delivery of 40 ml. Now, next page. Also, positive stock variation beyond permission limit has been observed in both the products since last inspection. You also kindly note that my learned friend was saying that prior thereto there was no such positive stock variation. Also, positive stock variation beyond permissible limit has been observed in both the products since last inspection on 22nd March 2023. Variation
Since March 2022.
variation beyond permission limit such and such at 17,900 liter and 13.0 respectively. The inspector has been handed over to you and the sample has been drawn for such and such. Now, whether initiating the fact-finding letter, they are in a predetermined mind to punish the petitioner or not. That is to be established first before your lordship. That as has been told by, as has been recorded before by the learned single judge. Now the inspection report has been handed over to you and the sample has been drawn as per enclosed report, the summary of irregularity mentioned below. Positive stock variation violation as per amendment. They have saying that they are, and now they are saying the violations which I have, as if I have committed those violations without instructing me to submit any reply. They have recorded that. Next, some photographs taken during the visit such and such. Next one, in view of the irregularities mentioned, predetermined mind or not. Serial number 1, 2, 3, 1, 2, and 3. Sales and supply of the retail outlet are suspended, have been suspended. That I have been instructed to submit my explanation. I submitted. I am not reading the same. It is page 88. Now you'll also kindly come to the page 90. The test report. Test report says, my lord, there is no such adulteration.
Yes.
Page 90, 92 up to, my lord, 93. These are the test reports. And my learned single judge has also recorded the auto-generated SAP information. From there, I will show later on that there is a, while there is a pouring the tank, there is a positive, the excess stock when actual stock is different. I have given the chart. I am not reading right now. I will read that later. Now let's kindly come to the show cause notice first. Now, page 103. How and which manner the oil company has issued the show cause notice in a predetermined. Because of I filed a civil suit against them in respect of other matter. I have pleaded in my writ petition also that. Page 103, it is dated 25th 11th 2002 and that has also been recorded by the learned single judge by passing judgment. Since I have filed the civil suit against them in respect of other firm, this proceedings has been initiated. But you have operating such and such in the district of such and such. Multidisciplinary inspected your return and following observation deviation were recorded during the course of inspection, such as they have. Now you will also kindly come to first positive stock variation, second non-availability of the reference density, non-maintenance of the stock. Now 4, short delivery of products with weights and measures still intact beyond permissible limit. They are admitting every time there is a short delivery. That is not, and for that there cannot be a termination. Now you will also kindly come to page 104. Last paragraph, clause 5.1. Next, accordingly, study was carried out and it has been observed that positive stock variation was attributed to unauthorized purchase of product as per clause 5.6. And without causing any inspection, without anything, they came to a definite conclusion that I have purchased product unauthorized. Accordingly, they have invoked as per clause 5.6 amendment such and such within stipulated as under. They have recorded also. Now you will also kindly come to page 105.4. Short delivery. if the dealer's responsibility to check the measures of each and every nozzle on daily basis and ensure that correct quantity and quality of the product is sold to the customer. Short delivery as per MDT inspection is 40 ml per 5 ml is beyond personal limit as per clause such and such. Thus, reply against such is not acceptable. Now let's skip the next page and now come to the page 107, positive stock variation. What is the this is all on so cause, not for any other termination. Positive stock variation, page 107. Positive stock variation beyond permission limit is violation of such a 5.1.11 and clause 5.1.6 of NG 2012 as detailed in point 1 above. The same is critical irregularity in the line of clause 8.2 which attracts termination at the first instance. Now you will also kindly come to page 108. In view of the above mentioned facts and circumstances, you are hereby asked to show cause in writing within 10 days from the date of issuance of this letter. Why action should not be taken as per clause 8.2 to terminate me. It is not that why we should proceed against. There is specific conclusion why we should not invoke clause 8.2 within bracket 6 to terminate you. 8.2 within bracket 6 of the amendment MD 2000 and in vogue of clause 3 such and such of the dealership agreement with you and for violations as amended in case you fail to submit time given you is not found satisfactory, we shall consent to take action as deemed fit. This is the so cause notice, my lord. Specific conclusion. Now you will also kindly come to page 109. Personal notice of personal hearing. Kindly come. There is a paragraph starts accordingly. A so cause notice. This is a notice of hearing. Accordingly, so cause notice it is such and such was issued to you for violation of clause such and such, not that or anything. And clauses 5.17.6, which is critical irregularity and attracts termination of first instance in the line of such and such. However, moreover, aforesaid acts and omission your part also tantamounts to violation of clause such and such. Man, they have definite conclusion in the hearing notice also, which is under challenge in a writ petition. I have challenged this so cause notice by filing a writ petition being WPN number 28450 of 2022. Since there is a definite conclusion and I filed a writ petition before this honorable court. What is my letter, your lordship, since the date of hearing was fixed on 27th January 2013? Your lordship, kindly come to the letter issued by me, by the learned, that is me. May I read my lord once? This is to inform you that the above referred writ petition was mentioned before his lordship such and such on 19th January 2013. When his lordship, considering the urgency involved in this matter, was pleased to direct the matter to appear on top of his lordship's cause list on 25th January 2013. Accordingly, said writ petition appeared in the cause list of his lordship of the Honorable Justice such and such as item number 36 dated such. However, due to paucity of time, said writ petition could not be taken up for hearing on 25th January 2023. I further inform that intimation was also given to your learned advocate responding the IOCL authorities in this regard. Next, I further inform that Honorable Court will remain closed on 26 and 27 on account of Saraswati Puja and 28 January 2023 and 29 January being the Saturday and Sunday. I further inform the above referred matter will taken up for hearing on 31st January 2023 or on next. In view of the above, you are requested to adjourn the date of hearing. A specific prayer to adjourn the date of hearing, since my point of defense with regard to the so-called notice with a definite conclusion was in this writ petition. You will also kindly come to the next page, that is the recording. If had they adjourn the date of hearing, heaven will not fall in a day. They have adjourned the date of hearing, allowed the writ petitioner to take his chance in the writ petition. They have not. You will also kindly see the recording of the minutes. This is the presence recorded, but it has been recorded that that the no reply to the so-cause notice has been found. They have recorded the same. I said, sir, the points of defense of my so-cause is in a writ petition. Now you'll also kindly. In reply to the so-cause sent to the ISL by the advocate notice, in reply to the so-cause notice, in reply to the so-cause was sent to the IOCL by the learned advocate notice informing that the filing of the writ petition in the High Court of Calcutta, all points of defense in response to the said so-cause were covered in the writ petition. I have not said so, my lord. My specific request to them to adjourn the date of hearing. It is their understanding that my all points of defense are before the High Court. Accordingly, they have refused to adjourn the date of hearing. Whether this amounts to violation of principle of natural justice or not. Without adjourning date of hearing, when there is a specific request, the High Court, the Honorable Court will remain closed on 4 days and the matter will be taken up 30th. They have waited, they have issued the so-cause notice on my lord, that is fact finding
24th September.
24th September. And they have issued the so-cause notice on 25th of November. And they have waited about more than 3 months. Have they waited another 1 day? Heaven will fall on that. I'm putting this question to myself. They have not. Now you also kindly come next day. They have waited for more than 3 months. If all points of difference, that is not my submission, but have been compelled to make some comments, and accordingly I have made so. Now my learned friend and shows some paragraph. However, my learned friend did not show the paragraph stated in page 30, page 37 of the writ petition. Paragraph 31, I have taken a specific point. Your petition states that termination of petition written out without granting the petition opportunity to submit reply to the so-cause notice violates all norms of rules of natural justice protected under Article 14 of the Constitution of India, such and such. Next, your lordship, kindly come prior there to. Sorry, my lord, I am sorry, my lord. Prior there to page 36. Your petition states that it is the well-settled principle of law that when the Honorable Court is in session of an issue and intimation has been made in this regard, the authority concerned in general course of business did not interfere with the same. However, in the instant case, despite making request to adjourn the date of hearing, the respondent IOCL in a revengeful manner, without giving the petitioner an opportunity to submit his reply, terminated the petitioner retail outlet dealership such and such. Violation of principle of natural 14, 19, 20 of the Constitution of India. Now you'll also kindly come. Now, my lord. Now the order of termination has been passed on 24th, 2nd, 2023, and which I have challenged by filing this writ petition. And while filing the writ petition, this Honorable Court has passed an interim order on 5th April 2023. I have handed over the copy of this. And it has been recorded in the said order. May I read once more? Petitioner has challenged the letter of termination letter of the retail outlet dealership by the Indian Oil Corporation. The grounds of termination appears from the impugned letter of termination. Before going into merits of the matter which relate to positive stock variation allegedly done by the petitioner, the relevant facts are required to be stated with regard to the conduct of the respondent oil company. The petitioner had filed an earlier writ petition being WPA number such and such challenging the so-called notice issued by the respondent oil company to the petitioner on such and such 24th September 2022 and 25th 11/20 respectively. The petitioner called for hearing since the earlier writ petition was pending, and the petitioner wrote to the oil company on 27 January already stating that the court will remain closed on 26 January 2023 and 27 January, and on account of substitution followed by the weekend of such and such 28 and January, the oil company was order in for the writ petition would be taken up for hearing on 31st January 2000. The petitioner accordingly requested the oil company to adjourn the scheduled date of hearing on such and such. Admitted facts that the oil company proceeded to hear the matter on such and such and terminated the retail outlet dealership by the impugned letter. The action of the oil company compelled the petitioner to withdraw the earlier writ petition on such a the petitioner, or for that matter, any litigant, must be given a forum and opportunity to ventilate its grievance. In the present case, the respondent company acted unwarranted haste and in the manner as to render the petitioner challenge infractions. There shall be stay of the impugned order. Considering the principle of violation of principle justice, this order has been passed. In my report, no challenge was made by the respondent oil company. They have accepted the order. Whether now they can say there is no violation of principle of natural justice.
It has merged with the final order, madam.
Pardon?
It has merged with the final order.
Now it has been merged, but when the order was passed considering this, they have not challenged the same, they have accepted the order. Now, my lord, it has been merged, that means it has been affirmed, since there is no challenge to this order.
Appeal is under challenge, this order.
Yes. But there is a termination now. Termination, my lord, is that your lordship, termination starts from page 150. Next page, your lordship, they have recorded the irregularity. Now, let's kindly come page 116. During the hearing, I am reading from the bottom second paragraph. They have recorded that during the hearing, adjournment was prayed for, even then. But they have taken the hearing on 27th January 2023, and they have passed the order on 24th February 2023, almost a month. What prevented them to adjourn the date of hearing on that day? They have taken the hearing on 27th and they are sitting tight over the matter for 1 month to pass an order. Instead of adjourning the date of hearing for a day. Saturday, Sunday is also a holiday for the oil company. I am putting this question to myself. Next one. During the hearing, it has been informed you that no reply to the so-called notice such and such was received by the IOCL. An opportunity was being given to you for making any submission. I could not read it. That the reply to the so-called notice was provided by the reminder. I have not provided any reply to the so-called notice. Where from my friend's client is getting this, I do not know. Reply to the so-called, I have prayed for adjournment only. Is if my letter is to be considered as a reply to the so-called? I don't know that. Next one. They found that there's a positive stock variation. Accordingly, terminated my dealership license. But when there's a positive stock variation, and if it is established that I have purchased the same from the outset, then only they can impose the punishment of termination. Otherwise, not. Only positive stock variation, there is no such punishment. According to my understanding from the brochure. Only it is established, they can prove that I have purchased the product from the outside, only they can terminate my license. You'll also kindly come to the brochure once. The brochure, it starts from page, my lord, 143. Starts from, my lord, page 143. Now you'll also kindly come to the page 176. Sorry, my lord. Just a second. But 176 first. Unauthorized purchased, sales, MS or HSD or any other product which could not be used as a substitute for this product. Dealers should purchase only those products, petroleum products, authorized by the person for sale. Purchase of the products from the source other than those authorized by the oil company, it will be treated unauthorized purchase. And this is the unauthorized purchase definition. Now you also kindly come to 178. In case of positive stock variation, 178. In case of positive stock variation beyond permissible limits, sample will be drawn and sent to the laboratory for testing. Sales and supply of the products be suspended immediately. In my case, that has been done. Study to be carried out to identify the reason for stock variation. Who has to do it? That the oil company is to do it, not by me. If the sample passes, but some other irregularity like unauthorized purchase, etc., is established. The word is established. Until unless they establish that I have purchased the product from the outside unauthorizedly, they cannot punish me, according to my understanding. Now, you let kindly come. They have said in the so-called notice, they have not said that they have carried out the study and identify the reason for stock variation. They have not said so in their so-called notice. In the fact-finding letter, they have said so, there is a positive stock variation. Therefore, what has to be done? They have to send the samples to the laboratory to testing for whether it is adulterated or not. And they have to carry out a study. That is specific point is there. In case of positive stock variation beyond permissible limits, sample will be drawn and sent to the laboratory for testing. Sales and supplies of all products be suspended immediately. That has been done. Study to be carried out to identify the reason for stock variation. They have to identify the reason for stock variation. If the sample passes, but some other irregularity like unauthorized purchase, etc., is established, they have to establish. Burden of proof lies on the oil company, not by the upon the petitioner. Action to be taken accordingly. However, if the sample fails, then another. Now you'll also kindly come to the punishment part, which they have invoked. (187), my lord, 8.2. But this 187 is to be read with page 178. Critical irregularities. The point 8.2, critical irregularities, man. Adulteration, I am not on that. Sales of metering unit, seals of metering unit found tampered, this is not applicable to me. Totalization seal of dispensing unit tampered, not applicable to me. They have said that seal was intact. Additional unauthorized fitting, that is not applicable to me. Unauthorized storage facility not applicable. Only unauthorized purchase, sale of products 5.1.6. But 5.1.6 says establishment by the oil company, study to be carried out by them, and they have to establish I have purchased this product unauthorized from the outside, then only they can terminate my license, no, or else no, according to my understanding. Now, my lord. Now, another submission was made by my senior friend, my lord, that so for the judgment of the learned single judge, may I read, required to read my learned senior friend?
Yes, read it. We have also read it.
May I place the judgment which I have?
So your contention is because there was violation of principles of natural justice,
it is maintainable.
It is maintained.
And another,
in terms of clause 5.1.6, it is the oil company after study has to establish stock variation, unauthorized purchase, and the burden of proof lies on them. And number 3 is, of course, that is also violation principles. That is, they could have waited. You sought for an adjournment. There was an interim order. Earlier writ petition filed challenging the show cause notice. Undue haste. Some malafide reason. Some
challenge was that definite conclusion. So cause is with definite conclusion that I have violated.
Pre-decided.
Pre-decided.
So mainly 3 legal issues. Principles of natural justice, burden of proof, whether the show cause notice was indeed a show cause notice.
And that our High Court has passed an order that's went up to the Supreme Court, Honorable Supreme Court, first single judge, then division bench, and where the appeal and the arbitration was under chance, where there is an alternative, the Supreme Court upheld the decision that alternative remedy is not a bar in regard to oil company also. May I?
In fact, I noted down a couple of points. Whether the oil company pre-decided the matter while issuing show cause notice, whether principles of natural justice followed, whether writ petition was maintainable when appellate and arbitration remedy available, whether marketing discipline guidelines would be binding on the writ petitioner, on whom the burden lies to prove that the stock variation was deducted. Next, whether the punishment of termination of dealership was commensurate or proportionate to the charge.
Another thing is matter of the
Whether the writ petitioner should be relegated to avail the alternate remedy. What will be the effect of the interim order? You have given 3 points. I made it into 8 points.
May I require to place the judgments?
Yes.
One thing, the short supply.
Oh, let him complete.
This is the well-known principle of well-known judgment of
Whirlpool.
paragraph 14 and 15. Hand over to focus on it. Paragraph 14 and 15. Power to issue prerogative claims. Paragraph 14 and 15.
Copy. That's of the case. Yes.
Next one is one of 2021 SEC online page 90 with Unitech Limited matter with regard to maintenance of the repetition. Paragraph 39 and 40. Even in the contractual case, paragraph 39. Maintain of the writ petition, even in case of contractual case also. May I read my paragraph 31?
Yes.
Two judges of the bench in ABL International versus such and such, and analyzing a long and petition of this court to conclude that the writ petition under are material for ascertaining the contractual right against the state or its instrument is as defined under Article 12 of the Constitution. Speaking through the Justice N. Santos H. in Court of Held, the following legal principle emerges as to maintainability of a writ petition. In an appropriate case, a writ petition as against the state or an instrumentary of a state arising after contractual obligation is maintainable. Next, merely because some disputed question of fact arises for consideration, same cannot be a ground to refuse entertain a writ petition in all cases as a matter of rule. Third, a writ petition involves consequential relief of monetary claim is also maintainable. My learned friend says this is a disputed question of fact, that's why I'm right. On the same issue, my lord. 2022 SCC online, page 639. Paragraph 21. কোনটা? হ্যাঁ।
They followed Whirlpool. Discretion in tandem with the law, depending on the facts and circumstances of the particular case. Yes.
And another judgment from our High Court. Bimola Gas Service, paragraph page 18, my lord. Page 18.
Can you check whether any appeal is preferred for us? But yes, sir. I remember. I think so an appeal was preferred.
I'm handing over the copies.
Oh, okay. It was affirmed.
Yes, affirmed up to Supreme Court. Page 9. I'm handing over the copies of the up to Supreme Court. Page 9, my lord. Inner page 9.
This was a case where they claimed there was a partnership agreement, suit was pending. And the division bench observes that that Sujit is not a party to the arbitration agreement. Therefore, the reference.
Since arbitration clause went up to the Supreme Court, SLP dismissed.
Question of law kept open.
Wait, or experience. Yeah. The last judgment is 2010, volume 13, SCC, page 14 of Oryx Pieces, right? Para 27.
Oryx Pieces. This is the learned judge's report.
Paragraph 27 to 35. These are my submissions. Appeal should be dismissed.
I should be allowed to resume my business.
This Oryx fishery, what is the paragraph, sir?
Paragraph 27 to 35.
27 to 30.
35. Is that my understanding is right in allowing the restriction by setting aside the termination as well.
No, that there must be a specific finding by any authority that what was the reason for 70,000 liters of MS and 13,000 liters of HST.
That, what explanation he gave at the first instance was that difference of 40 ml in the nozzle.
Yes,
for
my
every
lord,
5 liter.
40 ml in the dozen
But that can't be for 17,000.
that cannot match the 17,000 liters, my lord, and that was calculated, my lord. And apart from that, my lord, so far as short supply, in that event, there would be a negative stock variation. The measurement would be much with lesser quantity. Unless, my lord,
So if the dispensing is, no, his case is, if for every 5 liter there is 40 ml less fuel flowing through the nozzle, that 40 ml into 40 ml into 40 ml.
Yes, my lord, it's a totality that can, I understand that. That is one point, that every 5 ml contains 40 milliliters of deficit in supplying. So the 40 ml remains in the tank and that gets accumulated. Whether that can match the 17,000.
No, probably your thing is, he should have given a mathematical explanation.
Yes, my lord. But that can be done only within the duration of that particular period. That is from February to September.
The problem is, as per the agreement, the minimum quantity per month can be motor spirit 20 kiloliters, HSD 40 kiloliters, and grease 1 kiloliter or 1.
Yes, my lord, but the mathematical calculation is this, that closing stock plus the delivery minus the sales. On the date of inspection, that should match that. So this is a running
in
method.
fact, margin is normally given, evaporation loss.
Yes, that is there. That has been detected. That has been also been communicated. That is, this is the normal deviation, and beyond that,
how the decrease? Evaporation is the. But how the fuel went inside, the seal is intact as per the test report.
That is the thing, my lord. We have detected that. My lord, establishing must be on the basis of some inspection as well as from the communication from the dealer. He is not denied that.
No, he can't. No, this 40 ml theory, it can't match.
Apart from that, my lord, there is stock. What he is submitting, there is short delivery. In the event of short delivery, there will be a negative stock variation. Physically, there will be lesser quantity in the tank if there is a short delivery. Yes, that is.
No.
The moment
short delivery means
short delivery
40 ml will remain in the tank, will not go to the consumer.
Yes, my lord, no, SAP and automation, what he was indicating. There is another point, my lord. What is
this theory of this nozzle defect, in their order they say you have to upload on the portal, and it was attended within a day or two.
That has not been done.
Where have they stated that?
I have not been given
in the read petition, they have not stated that we have not attended. Rather, this point was discussed in the termination letter.
I have not given any chance. Submit my reply. I paid for adjournment.
Given a chance, but you didn't reply deliberately. There was no stay also.
Quantity is very huge, sir. That's what's disturbing.
And the time span, your lordship can list is the time span. During February 1st inspection, there was no deviation. In September 3rd, there was.
And from 2015, he has been operating. But of course, sympathy cannot.
Apart from that, what would be the fate of this particular product? 17,000 liters and 13,000 liters. Who are the owner? Who is the owner? Since the products are to be purchased by the dealer from the oil company and poured into his tank.
And he is having one more dealership also.
Yes.
Yes.
As I also indicated that he has specifically stated, since I have filed a writ petition, I didn't file the show cause. So it was at his own wish and will. He refused to file the show cause. And we didn't make the writ petition infructuous, my lord, by giving a reasonable opportunity of hearing, my lord. The order was passed 1 month thereafter, my lord. Hearing itself does not make the entire show cause notice infructuous or valid termination.
But during the hearing, he has made the submissions.
Entire submissions.
I'm compelled to make the submission. But what they are saying that my letter is a reply to the show cause, that is not true. And until and unless it is established there is a positive, I have purchased the same, whether they can invoke 8.2. That is the question to be decided by your lordship. If it is not been established, whether they can invoke 8.2 or not. They have to carry out the study, whether they have carried out the study to establish the same. They have not, according to so far the document which they have placed in the appeal, I could not find any document to show that they have carried out the study to reach to a conclusion that I have purchased from the outside unauthorizedly. There is no such document have been placed. They have carried out the study by following the rules.
Yes, that has been done and also been explained, my lord, in the in my affidavit in opposition to the writ petition.
This proprietor was not present on the day of inspection.
No, he was not present.
Because he says, myself was out of station for my daughter's junior Miss India Championship, where she is competing from West Bengal at India level.
Yes.
She won the competition?
Yes.
Huh? Oh, nice.
Now, my lord, so far as the deviation is concerned, my lord, that has not been denied and disputed. You know,
That's
all along he contended that there must be some justification. He shifted his
No,
cat.
their case is that it is you who have to establish.
But whatever be the stock, you are responsible to justify. But
in that case, there's a coming to the disproportionate to the punishment, whether punishment is disproportionate or not.
The only thing is it's a controlled commodity. That's the problem. If it is like water or something like that.
That is not the thing, Malad. That's why they have to follow the procedure, Malad. They have to follow the procedure strictly.
Let us see. Okay. We have heard Mr. Chakraborty, learned advocate appearing for the appellant oil company, and Mr. Bhattacharya. Mr. Bhattacharya, learned advocate appearing for the respondent writ petition. Hearing concluded, judgment reserved.
বাকি আর কোথায় বাকি তো judgment কোন আনরিপোর্টেড বিমলা কেস তোকে দিতে হবে ছেড়ে দে প্রফেসর রাত্রিবেলা করে বলছে এসএলবি টিকে দেখে দাও গ্রাউন্ডস দেখে দাও তাও পয়সা দেয় বিনা পয়সায় তুমি তো ফিস দেবে তাই ওর এটা নাকি